most one for residential, and 2 underage women, girls. Public knowledge.
I've forgotten before, and it's not a good thing. Good morning.
I can sit over here. This is where I sat last time.
Those are Shirley's chairs too, and make room for me. Someone drops something.
Yeah, sure.
internet too, right? I think it's
Mandatory.
I'm just asking.
To make sure your
I don't
phone's
know.
on.
You'll be good. But I won't, I wouldn't pay you a large.
All right.
I'm just getting set up, thank you. I appreciate it. I gotta make a couple trips out here.
We're one family.
And this is way more.
I don't know, that's I'm trying to figure out, there was a sign-in sheet before, I don't know if it's supposed to be or not. Cause there's also to know the transcript. Hmm?
That would be the honorable and classy thing to do, is to say, we will move up here, so that plaintiffs who drove for hours can sit. That would have been the noble thing to do.
Thank you. Go ahead, have a seat. Now, everyone, I required yesterday that everyone socially distance. That's still my rule today. I don't want everyone on top of one another. I want everyone to be respectful of everyone's space. And if you do not have at least a person or two in between you, you need to spread out. And that goes for the attorneys too. The attorneys get first dibs in this courtroom. I'm sorry, but they're the ones here who are arguing today. So if it makes it so the attorneys have to sit back there, then I'm sorry, some of the audience will have to go down to 6D. But I want everyone socially distanced as best that they can, okay? Has everyone signed in? Oh. I need everyone to sign in with Rihanna, please.
I don't know if it is.
It's a code.
And if you want to do that at a break, we can also do that too. Just sign in before you leave.
I'm good, how about you?
Well, the attorneys, where you're seated, are you comfortable? Are you socially distanced? Do we need to make room for you out in the seats, the audience? Please speak up.
I mean, I'm sitting right here. I don't know if you want to keep me between these two attorneys. We're at the computer.
I mean,
I can move it up, yeah.
I just don't want anyone, I just want them to socially distance. I would feel better if there was a little bit of, if you guys want to move over and go in front of the sliding doors to socially distance your chairs, that's fine, because I don't think people are going to be coming in and out of the doors there too much. So just spread those apart a little bit more. Right, they're going to, yes. Well, you should see her sign-in sheet. It's much better than we had first go around. You're trying to anticipate everything.
We can be fought.
Was there a lot of probate? Okay. I have to go get something that I'm printing and I'll be right back.
Excuse me? Williams, that you're transferring up here with, no? Was it filed here or filed here or transferred? No. Have you been in the case? You named defendant? Oh, it just got filed recently then? Weeks? Never heard of it. I don't know about any of that, but that's, well, what are they gonna do with all of that? Huh? Oh, did he? Oh, okay. I never heard of him. Huh? Okay, what's the last name again? Cadigan.
So just, yeah. Take on the-
Please rise.
Thank you. Have a seat.
Yes, there's 6 of us. Okay. I don't have a problem with it. Okay, understood.
All right, everyone signed in? The
Yes,
best we
ma'am.
can? All right. Okay, so Madam Court Reporter, if you can open the record. We're here on case numbers 2021 CH 5002, 5003, and 5005. The attorneys have all signed in on the sign-in sheet, so that will be made part of the record for today's hearing to show everyone's attendance. This was continued from January 5th.
5th, yes, ma'am.
January 5th until today because we ran out of time. So, I said we'd address the motion for leave to file amended complaints. Do you want to do that now,
That's fine, Judge.
Mr. Gerber? Oh, and for those of you who weren't here before, please identify yourself when you talk so that the court reporter can take that down. And if you stand up multiple times, please identify yourself again, just for her sake, please. Okay, but Mr. Gerber, go ahead.
Yes, Judge. Will Gerber in case 5003, Graves versus party defendants. As noted in the motion, Judge, just as recently as January 11th, the governor issued a subsequent executive order 2022-03, which superseded executive orders 24, which was amended by executive order 25. Associated with that, it amended definitions of close contact and symptomatic individual within those orders. It doesn't substantively change my complaint in any fashion, but the prayer for relief in count 1, count 2, and count 4 of the actual complaint, requesting that the court void what would have been 24 would now subsequently change to 2022-03. There was only one factual paragraph associated with the complaint that had to be added, just indicating that the governor did issue the new executive order on said date. There would not be any detriment to, I think, any party associated with the case by granting the motion, but it would be necessary associated with the arguments to be heard today, Judge.
The only concern I have is, and I know my esteemed clerk here has made me this chart to outline who has answered, who has responded, and who has that. I know pleadings are to be liberally construed, but I don't know if that will mess things up for today's hearing, because then those who have filed responses and or answers will not have answered by today's hearing. So I don't know if the defendants have any objection. If there's no objection, I don't have to worry about it. But quickly, does anyone have a position?
Good morning, Your Honor. Thomas Ferticchio for the Attorney General on behalf of the state party defendants. I assume your comment goes to both Mr. DeVore's motion.
Yes, it would
and
be to
Mr.
both of the motions to
Mr.
amend.
Gerber's motion.
I just don't know if it'd be best if we table it until after my ruling, because then I'm gonna be flooded with amended answers, amended TRO responses and all that. That's just what I'm thinking, but go ahead, Mr. Ferticchio.
That point is extremely well taken, Your Honor. There's also a point to be taken even before that, because while the state parties have no objection to the motion, nor frankly to the proposed draft amended complaints. I did notice that neither were verified. So while I assume you will give leave, they need to be filed, and obviously, under 2-605, since prior pleadings have been verified, they need to be verified. So once they're verified, then they can be filed. So that's the first preliminary issue, and then your also pragmatic issue about the defendants not having a fair opportunity to file a verified answer to the amended complaint is problematic, to the extent that we're talking about the TRO record.
Does anyone join in Mr. Verticchio's?
And I'm not even sure it's an objection,
Right.
because I assume you're gonna give leave to file, but
Right.
then they must be verified by the rules of civil procedure before they can be filed.
Counsel, plaintiff's counsel.
Judge, again, as to the issue about verification, it's really semantic. It doesn't matter, we can verify, but there's actually authority that says once the initial pleading has been verified, if it's amended, it doesn't need to be. But we'll attach 700 and some odd signatures, so it's not really a big deal. The point the court raises, I understand that. I mean, practically speaking, it's merely taking this executive order that the governor issued, supplanting the others. The substantive arguments are identical.
Right, I know.
You know, so to the extent the court wants to do it after this hearing, because I don't think whether you're looking at these two executive orders, 2425 or 22003, the court's analysis and underlying interlocutory opinion will be the same. It's not like it changes anything. So I don't have a problem with waiting until after the court rules, but to the extent that defendants have filed responsive pleadings, you know, we're not going to take issue with the fact that they addressed the 2425 executive orders versus 03. It doesn't change their arguments. But if they have concerns about the record and the court wants to wait, I don't have a problem with that either.
Judge, the only thing dependent upon the court's ruling associated with the court order, all the school districts have indicated what they're enforcing is the current order that's in effect from the governor. So unless the court was permitted us to actually incorporate 2022-03 into the formal court record today, it's going to potentially would affect any kind of order the court would issue in the event it is favorable. So I would argue it would impact any interlocutory order that would be issued based upon the arguments that have been made by the districts that they're using the governor's order to do what they're doing as a basis for everything within the state of Illinois.
That's actually a good point, Judge, that my colleague makes, and it could be prejudicial to the defendants, and I don't want to be prejudicial to them because the governor issued a new executive order. Many of them have issued responses to you and pointing to those executive orders as the basis for some of their action. And to the extent as we sit here today they've been superseded, it could hurt their arguments. I don't want that to happen. So however we have to come to, you know, again, some understanding that we have this new order now. I don't want anybody to be prejudiced by it, even the defendants in that matter. But true, a lot of them did point to it. Mr. Gerber's correct.
Any response from any of the defendants?
Thomas Verticchio, Your Honor, on behalf of the Attorney General. I'm not sure how this issue is solved in terms of the record, because while I appreciate Mr. Gerber's comment that they don't have a problem with it, that if we just stand on our earlier filed verified answers, it's not Mr. Gerber that's my concern. If, for example, the TRO is denied, there may be a problem in the appellate court that there was a second amended complaint and there were no answers. If the TRO is granted, there may be a problem in the appellate court that there was amended complaint and there were no answers. I don't pretend to know what the solution is, Your Honor, but I don't think it's go ahead and file and the defendants don't get an opportunity to answer before the court rules. That cannot be a fair and just resolution under the rules of civil procedure. I assume that the motions will be granted, and sometime, whether today or tomorrow or the next day, the verifications will come and there will be filed amended complaints. And at that time, the defendants should have an opportunity to answer, at least a matter of days. Thank you, Judge.
Mm-hmm.
Judge Wilgerber, just one last point associated with any potential appellate ruling, because the legal arguments, whether in the state's answers or in the complaint, substantively do not change. I don't think it would affect any formal appellate record at all, as the only thing that's changing in both of them is one exhibit.
But I guess the only thing I'm thinking about, and I'm trying to find here in my notes, I thought for the purposes of a TRO, if something is not answered or denied, then it's deemed admitted for the purposes of looking at the pleadings. So that was my only hesitation. Pleadings are liberally construed. I normally allow them. because I am thinking about the appellate court record. So let's say I rule in your favor and I issue a ruling tomorrow. They're not gonna have an answer on file, you know? So that's what I'm concerned about.
Whereas we do now, as
Right,
things sit.
exactly.
And that's fine, Judge, I understand that. So to the extent that my esteemed colleague doesn't stand up here in the next 15 minutes and try to argue with you, well, the plaintiff's case is all failed now because Executive Order 003 is authoritative, you know, if he wants to do that, so be it. But again, I don't think, however the court chooses a rule, this issue doesn't, in my opinion, change the court's analysis. But it just frustrates me that we have to even stand here and have this conversation, because now, yet again, we have the state level, you know, government changing the goalpost during the middle of litigation, like they did with the emergency rules. Now we're doing it again. So we can wait on amending the pleadings, Judge. That's fine. Let their answers stand. And again, if it prejudices the defendants because, you know, of how they've argued, I don't want that to happen. If they're not going to get their relief, I don't want it to be because of the governor's actions.
So I will grant you leave to file your amended complaints, but I'm gonna give you 14 days to file it.
Fair, yes,
We are
ma'am.
going to proceed today on the complaints that are on file and the answers that have been filed.
Makes sense.
You don't like that, Mr. Particular?
Well, it makes me nervous, because within 14 days, that could be this afternoon, and the ruling comes, and I don't have an answer.
Judge, we will not.
It
We will
just
not
makes me
file
nervous.
any amended pleadings until after this court has already ruled on the matters in front of the court, up to 14 days. We're not gonna play games with the court and enter an amended pleading in an hour from now when your honor's not ruled. Again, we've never played those games in the 2 years we've been in this issue, and we're not gonna start now.
So I'll do a docket entry. Plaintiffs are given leave to file their amended complaint after the court has issued its order. So then that way it's clear that we're proceeding on the complaints on file and the answers and responses that are
Yes,
on
ma'am.
file. Okay?
Thank you, Your Honor.
You're welcome. Okay. All right, with that being said, Mr. Gerber, I don't think you really had an opportunity to address the court. I don't know if you have anything you would like to start off with today to address the court.
Judge, I would. Once again, Will Gerber, associate with case 5003. Mr. DeVore briefly discussed this, Judge, as he started his argument at our prior hearing relative to separation of powers doctrine. Given the new executive order that was issued, this becomes somewhat problematic in relation to Executive Order 25. However, the analysis associated with what the governor is doing is the same, and whether these executive orders at all are valid associated with the issuance of them. So I would like to address that in part, given 3 Supreme Court opinions that have been issued from the 1960s forward. To note, I don't know if it would assist the court at all. I've got the cases printed for you if you would
Yeah,
like to see
I would
them.
welcome it.
Just for purpose, you don't have to print them off. in the
Thank you.
future or anything. Judge, the first case in Utel v. Walker.
Mr. Gerber, you have copies for us?
Associated with that case, 319 NE 2D 501, the court made a clear notation associated with that case that the governor's executive order was not within the confines of the governor's power. That actually, in my research, was the last executive order nullified by the state Supreme Court in Illinois. Associated with that, the governor in Illinois was attempting to regulate voting and political contributions associated with the state. In that executive order, he went through, he started making definitions for political contribution, purchase transactions, what supplies meant, what regulated business meant, what key person meant. We have 2 executive orders now on file that attempt to redefine words of quarantine, isolation, create new legal definitions for exclusion that are contradictory to definitions already set forth in the law. What's extremely important about that aspect, this was all done after numerous courts had already ruled that Executive Order 18 had violated due process in the removal of kids from school, as well as the masking of children in school. And the court specifically in that case quoted that the desirability of a governor to regulate must be distinguished from the power to promulgate regulation for purposes of separation of powers review. The Supreme Court then, in this Mackay v. Frelick case, which didn't specifically deal with the governor, it actually dealt with the court system, but went into further analysis the courts are to review when looking at the separation of powers doctrine. In that case specifically, the court system attempted to redefine the negligence statute that was currently in effect in Illinois. In a detailed review of that case, the Supreme Court noted the General Assembly is the only department of government entrusted with the power to change laws. They specifically pointed the power to interfere with or change a statute belongs solely to the legislature. In review of the then negligence statute that was in effect in Illinois, the court noted the General Assembly had incorporated the present doctrine of contributory negligence as an integral part of many statutes dealing with a number of particular subjects at that time. I would suggest to the court the principles of due process are extremely similar, as they're an integral process of not only the Department of Public Health, but general concepts of constitutional principles as a whole. The governor's attempts to redefine statutory terms in a direct attempt to remove due process protections merely undermine General Assembly statutes, constitutional principles, and 6 previous judicial rulings in Illinois. What's extremely interesting when I heard all of the school lawyers talk about the school's authority in this state, they all reference state police powers associated with taking care of children. When you look at the IEMA, specifically Section 4, this references the only specific police power of the governor in relation to taking. There are 3 subsequent paragraphs in the IMA relative to the governor's ability of takings that deal with specific due process rights of citizens in Illinois. So the IMA itself addresses due process in a huge substantive form, and just as the court indicated in that section, when you have due process incorporated all throughout General Assembly statutes within the IMA generally, I believe that's something the court should consider in determining whether these executive orders violate separation of powers doctrine. And then the Supreme Court issued the City of Waukegan case when we start dealing with intermixtures of governmental agencies. And the executive orders also do this when we start dealing with schools, start dealing with the Department of Public Health, and the governor's request to be able to dictate what these agencies can and cannot do. With that case, the court noted as a general rule, the delegation to administrators or agencies' quasi-judicial power to adjudicate rights or revoke privileges is not invalid as long as there is an opportunity for judicial review. What we have with these executive orders is an absolute request to remove the potential for judicial review from the orders themselves. Section 2C of the IDPH specifically calls for people's rights to a hearing, rights to attorneys, in the event there's issues of quarantine and or isolation. And the procedures set forth in 2C, 2D, 2E in the Department of Public Health are extremely detailed on these processes. And in that case, the Supreme Court specifically quoted, if the judiciary is given an opportunity to review what has been done, separations of power or due process, if you haven't, will generally be satisfied. This permits an aggrieved party the opportunity to contest fairness of procedures, the constitutionality of the substance of implementing rules and regulations, and correcting an administrator's interpretation of a statute under which it operates. That's not what we're dealing with here. We're creating new definitions, specifically of a word exclusion, that states that's attempting to trump words isolation, quarantine, modified quarantine that were previously in effect prior to the issuance of court rulings. And this removes the ability of the judicial system to review anything the school districts are doing. Now, defining close contact, probable case as a basis for exclusion in these orders are the exact concerns that are being expressed. Now, we have the school districts in here saying we've always had the authority to remove sick kids from school. There's never been a disagreement about that, and neither Mr. DeVore nor myself have ever made that argument to the court. The problem that you have, close contacts, probable cases, they permit the schools to take non-sick children out of school. And in my complaint, we have 2 students that have had this done and have been removed from public education for 10 days that were healthy because of these very definitions. So it is allowing schools to take healthy children out of school, remove them from public education without the right to be heard. And that's the problem with the orders. It's not because schools have the ability to remove sick kids. That's not the argument. And I have a specific child associated with my case that's subject to IEPs, special ed services, that cannot get these services because they do not have a right to be heard about why they're being removed from school when they're healthy. That's no different than discipline. Now, we'll hear the state stand up and try to indicate the governor has the authority to do all of this under the IMA. But two things are important. The words transfer and suspension appear under the IMA. I never ever read the word expansion in the IMA anywhere through provision, was it A through N.
Okay.
Those sections do not provide the governor the authority to redefine statutory law, expand statutory law, grant additional authority to agencies. He can suspend them or he can transfer it. None of that is happening. You read these executive orders, he's granting additional power and or restricting power, arguably, from local school districts to independently govern their districts in a manner that they see fit, which is a problem. So we would argue all of these executive orders, EO 18, 24, 25, which is no longer in existence, but violate the separation of powers doctrine and are void on their face. The procedural due process argument, Judge, has been hammered to great extent, and I won't belabor that point, but I would like to address the substantive due process argument that was in our complaint. In the packet I provided you, the Board of Education, the Tri-Point Community School District, which is a 4th district case. I know it's not from the 5th district. And that case specifically did not get completely through the mayors because the school district revoked their rule prior to the appellate court issuing its opinion. However, the arguments within that case are extremely on topic with what we're talking about, and also went through pretty great detail of several cases, Cook v. Edwards and Wood v. Strickland, a lot of cases that deal with substantive due process. In the answer that was filed relative to the TRO, the state seemed to indicate that kids did not have a substantive due process right to education. This case and the numerous cases cited within this case specifically indicate the ability to attend classes, the ability to not have your grades affected, the ability to receive grades. Those, you have substantive rights indirect to a public education. And as I indicated, I have 2 clients, one subject to an IEP, removed from school, did not receive services for a period of 10 days. Got an IEP team that doesn't meet to establish best interest goals. I have another client removed from school, not subject to synchronous education, no access to teachers during these periods of time. Those are substantive rights children have as a part of education. When children's education is unduly affected by what I consider arbitrary government behavior, we have a substantive due process claim. In the complaint, one thing we specifically noted, Judge, is these contract tracing policies permitting the removal of children who are not sick. These kids are not sick. If they've been allegedly exposed, are not showing symptoms, they still have to be removed from school. Previously 10 days, now 5. Because of that, we have districts not providing services, not providing access to teachers. Now, the contract tracing policies that remove children from public and private education, this unduly affects kids' education. And I attached the ISBE, the State Board of Education, and the specific opinion that synchronous learning was extremely important. At least 2.5 hours of synchronous learning was necessary for kids to maintain education associated with removal. That's not being done throughout the state of Illinois. And from a substantive right, if kids need access to 2.5 hours via professional recommendation to maintain adequate grades, I don't understand how the state is indicating that these executive orders that provide removal for non-sick children are somehow satisfying the educational principles of children. Now, because we're dealing with what we consider a fundamental right for kids to have access to education uninterfered, we're dealing with a strict scrutiny analysis for the substantive due process claim. Because of that, the state's got to show the means adopted have a reasonable method of accomplishing the desired objective. We would argue the relationship does not exist in the issuance of these orders, and the children's education is being unduly jeopardized. In that packet that I handed you, Your Honor, I attached the affidavit that the state filed from Dr. Susan Casey in their answer to the TRO that we filed. As a basis for the issuance of these executive orders relative to children, on page 24, specifically paragraph 22, children, there are 62 cases per 100,000 kids that will acquire it. Nationally,
Would you say 100,000 or 1,000?
100,000.
Because I don't think I have all the pages here, but I do have the affidavits in my office, so. But you said paragraph 24, right?
22.
22, okay.
Yep.
Thank you.
Paragraph 23, hospitalizations associated with children in COVID. 0.07 per 100,000 children. Not even one child per every 100,000 children would even go to the hospital. As of October 29th, 2021, this went up to 0.2 children per 100,000 children. You were talking about a statistical issue of 99.99998% that children will be unaffected by this issue. So when we look at the potential, strike that. What I can't figure out with this, are we supposed to be worried about people acquiring it or the potential impact on the children? And I would argue clearly, even the statistics provided by the state themselves, the impact on the kids, does the means justify what they're doing? And when we start comparing stripping of freedom based upon statistics like that, when they start talking about balance of hardships, it's very, very difficult for me to understand. The second point I would make with that, Judge, they continue to talk about all of these cases spiking, number of cases spiking. If the means that they're attempting to adopt within all of these orders are so effective, why do the numbers continue to spike and continue to allegedly spike, yet kids' rates of potential impact stay at 99.99998%? So in looking at that analysis, Judge, we would argue also that these violate the substantive due process rights of children. They violate the separation of powers doctrines, and these orders, I believe, are void on their face, and the TRO should be granted. Thank you.
Thank you. Any response from anyone? I don't have any particular order.
I'll go. Happy to do it. Good morning, Your Honor. Jason Manning
Hello.
on behalf of Yorkville District 115 and Dr. Timothy Shimp in the Graves matter. Also represent Yorkville in the 002 matter as well, but I'll only address.
You also addressed you in the WO.
I'm sorry, we also represent Yorkville in Yorkville 115 and 002 matter.
Well, I would encourage you to say everything now because we're limited on time.
Fair enough. There's been a lot said, so
Yes.
I'll keep my remarks brief and for now just address Mr. Gerber's argument with respect to our client. And just to be clear, it was my understanding from the last hearing that Mr. Gerber wasn't going to be arguing specifics about the school districts, but since he raised those issues, I'm going to deal with them.
Okay.
Our client does not have the student he spoke of that has a special education issue, an IEP. That's the other school district that's named. There's two school districts named in Graves,
Okay.
Plainfield and Yorkville. I represent Yorkville.
Okay.
So just to be clear on the record.
I'm going to note that, so thank you.
Sure. First, I want to address the point that was raised that the student, at least in Yorkville, didn't have access to education while she was excluded. And so the record's clear on this. This particular student was only excluded for 4 school days. And during that time, she had full access to remote learning as set forth and required by the state superintendent for the Board of Education. And we've covered this, but I'm going to mention it again. The General Assembly set up this framework to provide students with remote learning during a pandemic such as the one that we are in. That's Section 10-30 of the school code. And we've heard a lot about the General Assembly should act. They have acted. And pursuant to that statutory delegation of power, the state superintendent has set forth the requirements for remote learning. And Yorkville followed those requirements. We have a verified answer in that case. We've provided those materials to you. We have an affidavit. We've attached to our response as Exhibit O to our affidavit what the remote learning requirements actually are. Mr. Gerber argued that districts are required to provide synchronous learning. It's simply not what the requirements say. If you go to page 2 of Exhibit O, in our response brief, it says the remote learning requirements, quote, are the same as they were last year, specifically 5 hours of a combination of instruction and schoolwork with a strong recommendation, not requirement, that districts strive to provide all their students with at least 2.5 hours of synchronous learning, end quote. Now, of course, everybody would prefer that students are in person, but it simply is not true that there's a legal requirement under the state superintendent's declaration of the remote learning requirements that the amount of synchronous learning that Mr. Gerber claims this client's entitled to be provided. Be that as it may, we have an affidavit in the record stating that the district is now providing more than the recommended synchronous learning, so that issue is moot with respect to this motion for a TRO. It's simply moot by the undisputed record before the court.
Okay.
Judge, that's all I have to say on that particular case. I do want to make one point with respect to both matters, the 002 and the 003, with respect to what's in the pleadings. And we've heard a lot about, what's in the actual complaint and what's at issue before the court. And it's our position, we briefed this in the 002 case, that what the plaintiffs have put at issue in this case is the state's executive orders and the rules promulgated by state agencies. They brought in 145 school districts because those districts are following the state's requirements. But there is not a single allegation in the 002 case about, or frankly, in the 003 case, there's more in that case, but I've already addressed it. In the 002 case, there's no allegation about what any particular school district is doing different than what's required by the state requirements or what they have said they might do in the future. It's just not before the court. And what the plaintiffs are asking, by asking you to rule well beyond a challenge to the state's executive orders, is frankly premature, and it's improper. And we've cited the case. It's Weber versus St. Paul Fire, 251 Illap 3rd 371. The law is clear in the state that courts should not hear unripe or, quote, hypothetical cases or to enable parties to secure advisory opinions or legal advice from the court with respect to anticipated future difficulties, end quote. And we talked a little bit at the status hearing before these cases proceeded about whether bifurcation was appropriate, and we're not there. The plaintiff has kept the motions in front of you, Your Honor, asking for relief all the way. They're asking for the home run swing. We'd ask that respectfully you deny the TROs on both cases, and in particular the relief they're seeking that goes well beyond the state's current requirements and seeks to get an advisory ruling in order, barring the districts from doing anything that they may be able to do or may choose not to do under their discretionary powers. Thank you.
Is that Weber case cited in your motion? I got the site down, but,
Yes, it is.
okay,
Take one.
thank you.
Judge, can I
No.
Yeah, I like to have them respond back and forth. Sorry, counsel. Go ahead, Mr.
Just to
Gerber.
make clear, there was no relief associated with my argument against either one of the districts, just like I'd indicated to the court before. So, just so Mr. Manning's clear, I don't know, associated with the Plainfield attorney, there was no specific relief with the TRO being made against the districts.
Okay,
But associated with everything that the schools have said that nobody knows, have the authority just to pull sick kids out of school, I want the court to know specifically the 2 kids subject to my complaint, that is not what always is happening. So it's used specifically as an example. There's no relief being sought against either Plainfield or Yorkville directly associated with this TRO hearing.
okay.
Judge, Mr. Manning took a brief opportunity to cross over and actually not just respond to Mr. Gerber, but address the 002 case. So at some point in time, I would like a brief moment to respond
No,
to what
I
he said,
want you
just
to-
whenever we get there. No,
No,
I
I
don't have
want-
to do it now.
No,
Can we do it now?
Yes, because
Thank
it
you.
helps
Sorry,
keep my
Nick.
notes straight, so.
Judge, I just had 2 things as it related to Mr. Manning's comments. Is he conflates the issue of the remote learning statute that was passed by the legislature, which I have, again, at least as of today, no issues with, where it said the state superintendent during the times of a disaster may implement a remote learning requirement for a district, the entire state, et cetera. Judge, an exclusion policy and whether or not we're going to exclude specific children for a potential close contact issue is not, and then again, if that child is properly excluded, they need to be given remote learning, it's not the same conversation. It's completely 2 different things. So the state superintendent's authority under the remote learning statute and whether or not children are being properly excluded from school and then offered remote learning, legally they're 2 completely different things.
Okay,
And then to suggest that, somehow or another we haven't raised the case against the school districts, Judge, quite simply, these school districts have been named in this case for the plain and simple reason that they have implemented these masking and these exclusion policies in their school districts. Now, Mr. Manning just pointed out to the court, well, we've implemented the state requirements. Have they? Because I've listened for 4 days that, well, we have this inherent authority. I really find it interesting. Are you using your inherent authority? Are you doing what the governor told you? I don't know. But again, it doesn't matter for the analysis the court's doing now, whether they think they have the inherent authority or whether they're merely doing what the governor and the agencies are telling them to do. It doesn't take us away from the underlying legal analysis of can any of them do it. and disregard the Department of Public Health Act as it relates to the masking, the quarantines, exclusions, et cetera. So why they implemented that policy doesn't matter. The fact of the matter is we have pled that they have implemented it and they are doing it, and we say that it's unlawful. That's all I have.
Okay, thank you. All right, now your turn.
All right. Jennifer Smith, standing up on the Graves matter, the 003 for Plainfield and Superintendent Averill.
Okay,
And then I understand you want us to make our remarks, so then I also represent Plainfield and the other 16 school districts that joined in their brief in the Austin matter.
okay, and you don't have to name it.
Okay. So I'm gonna be jumping around a little bit because of that. I suppose the first thing I want to clear up is what Mr. DeVore just argued about whether or not they're seeking relief against the school districts.
Okay,
So there is a bar that the state set. You must comply with these requirements. And we're all under that bar, and we've talked about the enforcement. And so many school districts are implementing certain policies right now, in part, one reason, because the state has required it. If that bar, now, where Mr. DeVore has confused the school district's arguments, I think, greatly, is that the argument is, if you grant his authority on the state and remove state authority, some of our clients, then our clients still have authority, perhaps, to do what they're doing now. They could agree with and have their own independent reasons for pursuing similar policies as what was required by the state. Or they may use their authority and have more nuanced, different approaches. I think we would see different approaches across the state. Our point, and I think they are seeking relief, I understand the request to be, if the state doesn't have authority, they want us to walk out of here and schools cannot require masks for any reason. That's how I understand the request.
no.
Is they're saying that you're preserving our authority, so we're gonna walk out of here and all they're asking is that the state cannot require masks and exclusion, but schools can still do what they want. Because I think we have a different dispute, and that's not how I read their pleadings.
Okay,
So what we've all been arguing about, to my understanding, I won't speak for anyone, but is that our authority as schools is preserved regardless what happens with the state. And like I
Right.
said, our clients will use it.
understand that.
And so we do not want to walk out of here with our clients not having their independent authority. Now, that's different, there have been criticisms of, you've had this independent authority this whole time, yet we were hearing that you're just following the state. Two different things. Yes, some districts are following the state right now, because that's a requirement, it's a bar that we could exceed it, but we can't go below it right now, or we'll face state authority. So that seems to have been confused. Saying that we have local control is not in conflict with saying we also are following the state mandate right now that exists. It's very important to all of our clients that we walk out of this court today, or whenever you make your ruling, still with the authority whatever happens to the state, because we need that to operate schools. And that's where I wanted to expand on my arguments to the court yesterday, because we've heard about the provisions in the school code that generally say schools have authority to operate schools. And I talked about what that means. There seems to be questions about, well, that's not specific. That doesn't mean you can exclude close contacts. That doesn't say you can require students to wear masks. So I want to give an example of absolutely operating a school means having the ability to implement school health services in a school. And there seemed to be, again, a lack of uncertainty or questioning on what does that, you don't need, to operate a school doesn't mean require masks. Well, in Individuals with Disabilities Education Act I talked about yesterday, yes, we are required, it's in federal statute, I can provide the site, we're required to provide school health services. Supreme Court case, Cedar Rapids v. Garrett, says that includes things like school nurse services, suctioning, catheterization. We are talking about serious school health services by trained professionals that follow the health guidelines for those things. So to say that we could not then require those in our schools that are required to catheterize, that are required to suction, tubes, that we would ever walk out of this court and not be able to require them to wear masks, that is operating schools. That is the work of schools. So when we say we have authority to operate schools, yes, it extends to requiring masks in certain settings where we have to not just vaguely provide safety, but to implement our responsibilities for students that we care for that have significant needs. So I just didn't want to leave any uncertainty that is the work of schools. Next, Mr. Gerber, again, I think he's clarified that he's not seeking relief against the school, that he was using his complaints against Plainfield as illustrative of the situation, and brought up the student with an IEP that is in my client's school district.
Okay.
I mean, one thing that's key to point out, the alleged facts, the exclusion was in September. We're here on a TRO. Where is the emergency? The student has not been excluded since September. And then when you talk about due process, he talks about a lack of a concern about IEP services. Again, there is a requirement to exhaust administrative remedies if there is a dispute about IEP services. And we're talking about something that happened in September with no request for an IEP meeting and no due process complaint filed, let alone exhausted before we get to this court. So you talk about due process. Yes, there's a lack of due process. They have not exhausted administrative remedies, yet they're using that as an example of why the court should enter a TRO sitting here in January. Your Honor, in terms of jumping around a little bit, you raised an issue about a slippery slope the other day and about, could schools require students to take birth control? Is their power, are we talking about this boundless power? This is a highly regulated area. There's specifically a federal regulation. No, we cannot require students to take controlled substances as a condition of education. That is prohibited. And again, this is such a highly regulated area when it comes to meeting individual health needs of students that there is not a slippery slope concern. Their parents have detailed, extensive rights that have not been pursued in this case, but that's why we shouldn't be before the court.
I have a question for you. With this independent authority that everyone is, not everyone, I'm sorry, but the districts are claiming, if you have this independent authority to have the students wear masks, then why haven't you done it in the past with regard to the flu? This is just, I'm not saying specifically, I'm just giving a hypothetical. If you have that authority to do that and you're saying, we don't have to look at, the bar, then why not require students who have them to wear masks in the past because they have the flu? It's passed similarly, my understanding, of how COVID is. And I don't think there's a right answer, I'm just playing devil's advocate.
So we look to our health experts, our public health departments, our different resources that we have to give expertise, and we do take that into consideration and follow it. To my understanding, there's different recommendations for the mitigation of different diseases.
Okay.
And right now, the recommendation for the mitigation of COVID, on the record, you've seen the affidavits from the health experts saying this is a recommendation specific to this.
Okay.
We do things to mitigate other diseases. And it might not be the same mitigation, but we do, we do them, and so that's important to know too. This is, again, our status quo is we consider the recommendations of health experts, we consider our facilities, we consider our staff, we consider the specific needs of the individuals in the classroom, and we make decisions to protect their health and safety.
Okay.
Thank you, Your Honor.
Thank you. For Mr. Verticchio, any response?
Yes, ma'am.
I was gonna have Mr. DeVore respond to Ms. Smith before you go.
Oh, I didn't construe her as commenting on Mr. DeVore's case, but I guess
Right.
maybe she did on a point or two. My apologies.
That's
Judge.
all right.
Judge, I just listened to a lengthy conversation about school health services. Judge, what we're talking about is not providing school health services to the individual health needs of particular children. That's what she's talking about. You know, they have to provide catheterization, suction, etc. Provide these services, she said, I wrote it down. Yeah, I'm starting to become like Mr. Verticchio, I hate to say. Provide these services.
What do you hate to say?
Provide services to people in need. Individual health services. I get that. That's what we're talking about. We're talking about forced medical intervention on children when parents are objecting. They don't want it. But we're going to make you take it, Judge. That's not even, you can't put them in the same universe of providing these health services to these children that are in need. It's not even the same thing. Is a masking policy mandating you do this or you can't come in this school? Is that an individual health service for children in need? No. Is saying we're going to exclude you from this building because we in the school have determined that you are a public health risk. Is that an individual school health service? Judge, that's a stretch beyond. I was really trying to use all the mental gymnastics in the world that I could come up with to say, okay, I understand that argument. I'm willing to accept arguments that I may not like, but I can appreciate and respect and understand. I can't put them together, Judge. One has nothing to do with the other. Then the comment was, well, as you asked, or I think counsel brought up again about the providing the, what was it for the children? It was for the, the abortion, not abortion, what did I get on that for? Yes, thank you. For children taking the pill. I was like, I got 2 teenage daughters, that conversation gets me all clustered. When their mother told me that the first time, I stuttered like I am now. So you guys know I will stutter when you talk about my teenage daughters. But Judge, she says that was a highly regulated area. You know what else is a highly regulated area? This stuff. Quarantine, exclusion from school. There's whole provisions and statutes about this that we have laid out. Is that not a highly regulated area? I don't know how the individual health services, not even and dealing with the thing, well, these are highly regulated areas. This is a highly regulated area. And then the last thing that I have for you is, again, we keep, and this has me confused as much as well, dealing with this inherent authority versus the state level. I'm really trying to reconcile all of that. Well, we have this inherent authority, and as Mr. Swain went over and over, you know, unless it specifically says that we don't have it, then we have it. Where does it specifically say that the state can enter a rule that vitiates the authority or that we have to listen? Because I think we all know, we can stand here as adults and all say that overwhelmingly these school districts fell in line with when the state issued these enforcement mechanisms. Their inherent authority is superseded by these state level actions? Where's that written at? It's not. Is it the fact that they use the governor as a scapegoat in their school districts? Maybe. But Judge, they either have the authority or they don't have the authority. And I would add to you, even if they have inherent authority to manage their school districts, and they do, they're an independent legislative body of government, they have their authority to manage their school districts. Is that so broad they can engage in matters of public health? That's really the question for you as it relates to their authority. and it's a separate analysis for you as it relates to the governor and these agencies, is their inherent authority so broad from these general statutes that they've given you, that they can make rules and regulations for the operation, etc.? Is it so broad that they can engage in matters of public health, start excluding and putting requirements on perfectly healthy people? Judge, it's not. I'm asking you to find that it's not. Because otherwise, there's no limits to what their authority is. And again, you brought it up with your example. Well, could they enforce that? My colleague says, no, it's highly regulated. What we're talking about is pretty highly regulated too, ma'am. So again, their inherent authority does not allow them to create conditions upon which children must comply or you can't walk in this building. They can't point you to any specific provision that generally, a general proposition that says you do this or you can't come in this building until you decide to comply. And that's just the end of the conversation. They can't do that. Thank you.
Thank you.
We're talking about birth control. My teenage daughters, I get all stuck. I can't do
How
it.
you doing, Nancy? Nancy, how you doing?
Fine.
You need a break?
Yeah.
Okay. We forget about how much the court reporters are doing.
Exactly.
All right, Mr. Peticchio.
Your Honor, I think both Mr. Gerber and Mr. DeVore have conceded that there's just a tremendous amount of overlap between the allegations and claims in Graves and the allegations and claims in Austin Hughes. There were a few things that Mr. Gerber raised that I did not intend to cover when I get my turn in Austin. So I think it makes sense, but if you disagree, you'll tell me, to let me just comment on a few things that Mr. Gerber said, and then I'll sit down, and when I get my turn in Austin, I will bring the more global issues.
I don't know.
to front.
I don't know the right way to do it.
I know, for example, Your Honor, that, and whether we stumbled into it or not, that the school districts were given their first crack in Austin, and that took the day the other day. But I know that there are a few of the school district attorneys that have some comments they want to make this morning.
Okay.
And then after that, I intended to make the presentation
I
to the
think that's
state
fair.
parties. So that,
Yeah.
so
let's do that.
just a few comments with regard to Graves that were discrete with Graves, and if they're not, I will tell the court. Mr. Gerber made a point of the takings provision in the Emergency Management Agencies Act and the process set forth in the takings provision. You can search the Graves complaint high and low. You can search Austin and Hughes too, high and low, and Allen if you like. There's no takings claim here. None, zero. I don't know what the reference is even about, but to the extent that the court is idly curious about takings and that section of the statute, can't imagine why you would be. It's there, but it's not in this case. The separation of powers argument, I will leave that to our brief. It's at pages 5 through 11 of the opposition to the Graves TRO. And Your Honor, and the only reason I stress the Graves TRO is because it was originally filed in Kendall County.
I think that's right.
Kendall County.
Yes.
So it may slip through the cracks. I know you have it, but it's a Kendall County
No, I like
caption.
stuff being pointed out, because I do take the notes on that, so thank you.
Certainly. Mr. Gerber talked a bit about the appropriateness of the agency actions and the emergency rule. That's obviously front center in the Austin case, so I'll deal with that later. The comment about, well, this is evading judicial review. Mr. Gerber talked about evading judicial review. Two comments there. That claim's nowhere in this case, but more importantly, I'm sure that's a surprise to everybody, particularly you, to suggest that these claims are not subject to judicial review. We are judicial reviewing it to death. So not sure I understand that. And then finally, on substantive due process, that's a claim that Mr. Gerber talked briefly about that's on a constitutional level is not raised in Austin. So just a few comments about that.
Okay.
Primarily rest on our brief, and again, it's in the Graves TRO opposition. It's pages 18 through 24,
Thank you.
which we go through the various stages of judicial review, rational basis, strict scrutiny. But on a broader point and more important point, none of that's necessary. Because, and this is in the brief at page 20, the law in Illinois, and this is word for word from the Bigelow case that I know you're familiar with, 377 Illinois Appellate 3rd 165 at page 180. Quote, if the interest is not fundamental, comma, the government action is entirely outside of the ambit of substantive due process, period, close quote. So if the interest being brought forward through the claim is not a fundamental right, a fundamental constitutional right, the governmental action is not subject to a substantive due process claim. That's the law in this state. There's no denying it. So where does that lead us? The question obviously is, well, is the education of these children a fundamental constitutional right? And the Illinois Supreme Court in Community for Education Rights versus Edgar, it's in the brief, but it's 174 Illinois 2nd 1 at page 37, said that a child's interest in education is not a fundamental right. Quote, is not a fundamental right, close quote. Unless it's a fundamental right, government action doesn't trigger substantive due process. That's the law in this state. The Supreme Court tells us education is not a fundamental right. And Mr. Gerber chose his words carefully, because when he was telling the court about the rights in education, he said the law in this state is undoubtedly that children have interests in their education. True. Interests in their education. That's far from a defined constitutional fundamental right. So for that reason, while it's in the brief, the court can march through the rational basis analysis, the strict scrutiny analysis, and determine that there is no substantive due process claim. You don't need to go that far, because it's as simple as no fundamental right, no substantive due process, and there isn't a fundamental right to education. Beyond that, Your Honor, I will address the rest of the issues when it's my turn in Austin. Thank you.
Thank you. Any response, Mr. Gerber?
Yes, Judge Will Gerber. Associated with judicial review, just so the court's clear and counsel's clear, I'm talking, and I think the complaint's clear and all the arguments have been clear. We're talking about individual masking related issues by the definition of exclusion within these orders. So when a kid comes to school and or associated with contact tracing can just be removed from school because definitions of quarantine, modified quarantine are stricken from the law, the court is specifically removed from the process by very modifications and attempted definitions within these orders. So this is in relation to individual masking processes, individual exclusion processes that the school is going through currently. In relation to the takings issue, Judge, this was used in parallel to what the court was talking about when due process is also an integral aspect of other portions of statutes for separation of powers related review. And for the state or schools to indicate due process should not be considered associated with this case, the governor's inherent authority that they're arguing under the IMA, due process is specifically referenced, associated with policing powers of people within Illinois. So for it to be identified by the state parties or other defendants, that should be somehow ignored when it specifically set forth in the statute, I think to be odd. Judge, I would encourage you to read associated with the question of fundamental rights in education, Wood v. Strickland, Cook v. Edwards, these cases issued by the U.S. Supreme Court relative to the substantive due process rights of kids and exclusion protocols of schools associated with that. And in these cases, removal from school unnecessarily, specifically the Supreme Court has indicated, sparks substantive due process review by the court systems and is subject to substantive due process review. And I think it was Mr. Swain when we were here previously, in his lengthy constitutional due process argument to the court, further touched on these arguments as well. So for Mr. Verticchio just to say a child does not have a constitutional substantive due process right to education is just inaccurate, Judge.
Your Honor, if I may,
Yes.
the cases that Mr. Gerber just referred to, the court from where those cases came, the United States Supreme Court. He's talking about a federally constitutionally protected right. And I will challenge the court. I'll challenge Mr. Gerber to look anywhere in his complaint where he raises a federal constitutional claim. I know it's not there, because if it were there, that leads to something. In most of these cases, it's led to something called removal. And as a result, plaintiffs, you were unable to dodge that one. But as a result, the plaintiffs' lawyers, Mr. DeVore, particularly Mr. Gerber, Ms. Hager, they've been very careful over the last course of months to craft their complaints not to trigger a federal constitutional claim. And that's why we're here.
Okay.
So the issue is Illinois law. Illinois law says unless it's a fundamental constitutional right under the Illinois Constitution, there is no substantive due process trigger. And the Illinois Supreme Court says, yes, there are rights to education. It's not a fundamental constitutional right under our state constitution. Thanks, Judge.
All right. Thank you. Okay, let's just take a quick, literally like a 5-minute break, stretch our legs, get a drink, and then come back on the bench, okay? Thank you.
Oh, sorry, yeah.
No, you're fine.
referenced other cases
That's
there.
Clinton County?
That's Clinton County. So the
Okay.
correct citation is 2021 MR 89. Apologies for the confusion. Mr. DeVore sued too many of our clients. Additionally,
I'll stipulate that we agree on that, Judge.
we do. Additionally, Your Honor, there are a few of us who were unable to address the court on the 5th that would like to do so very briefly. I've talked to my colleagues. My comments will take less than 5 minutes. My colleagues are going to attempt to do the same.
Perfect.
We are happy to, I believe there's 6 of us, counting myself. We're happy to do that back to back to back. Let Mr. DeVore respond afterwards rather than a protracted back and forth. I've discussed that with Mr. DeVore. He had no objection.
Okay.
If the court would entertain that, we're happy to do it to move things along.
Nope, let's do that.
Okay.
I like it.
You've heard lengthy arguments, Your Honor, on the underlying merits in the case, and I'm not going to address those, but I would like to address 2 narrow points today because we have not focused in detail on the elements of a TRO.
Okay.
And I think there are 2 narrow but very important points that the court should consider regarding the balancing of the equities and irreparable harm. First, in terms of the balancing of the equities, the court must consider the potential federal liability that school districts would incur if mask mandates are prohibited. As has been previously cited, the JBL Properties case holds that even if the first 4 elements of a TRO are met, a TRO cannot issue if the equities don't balance. As we've noted in our brief, in at least 5 separate federal cases, prohibitions on mask mandates have been held to be discriminatory against students with disabilities. In those cases, the courts found that the executive orders that prohibited mask requirements or that allowed a unilateral opt-out were discriminatory against students with disabilities because choosing to wear a mask while other students chose not to did not allow the students with disabilities to attend in person. Those are federal cases, but those come out of Iowa, Tennessee, and South Carolina. We're not citing a head scratcher of a Ninth Circuit opinion here. Moreover, one of those Tennessee decisions was a stay was recently denied by the Sixth Circuit in late 2021. So because a TRO is an extraordinary remedy, districts should not be faced with potential federal liability or federal intervention until this matter can be fully litigated.
But
Second,
I just want to say that I don't think, and I thought Mr. DeVore has made this clear, he is not asking to overturn the mask mandate. He's just saying if there is a student who, because a contact tracing, who is healthy or otherwise, is being forced to be excluded or wear a mask, he wants them to have due process. He's not saying there's no mask mandate.
I disagree with that, Your Honor.
Okay.
I think that the prayer for relief in his complaint would prohibit school districts from requiring masks and prohibit school districts from close contact exclusion.
Okay.
In yesterday's case, and those records are a part of this, Mr. DeVore acknowledged that the school authority only becomes an issue if the state mandates are struck down. And he agreed with that the court
right.
need not address schools' authority to impose a mask mandate or impose temporary exclusions unless the state mandate is struck down. Currently, districts are imposing those requirements because we are required to do so. So
Okay.
in terms of the question, why haven't districts done this before? At effectively all points during the pandemic when schools have been open, we have been under an executive order that required masking. Okay? Why didn't the districts do this before? We weren't in a pandemic before.
Right.
In terms of the flu, school districts have always taken unique approaches. School districts have shut down for 2 weeks if there's a particularly bad flu outbreak. Those things happen. So districts have done that. You know, Mr. DeVore has repeatedly said none of them have the authority to do this. So I absolutely think that the prayer for relief is seeking a prohibition on school districts from imposing their own mask requirements. So if the state mandates were struck down, we have 140 some school districts, and I suspect you would have 140 some unique plans by school districts on how they were going to manage that. Some of those plans would likely be very similar to the mandates that are currently in place. Some of those districts certainly would not require masking. Even within the 11 districts we have in O2, there would be numerous iterations of what school districts would do.
Okay.
The prayer for relief absolutely would prohibit those districts from doing that. So
Okay.
that is, if Mr. DeVore is not seeking a prohibition on school districts imposing their own plans, then 90% of us can go home, and Mr. Verticchio is perfectly capable of representing the state's interests. I think we would all applaud and walk out of your courtroom and you could be done with us.
Okay.
But none of us read the prayer for relief that way, and I don't think that is the practical implication of it at all.
All right, thank you, that's
So-
insightful.
My second point is in terms of irreparable harm. As we stand here today, there is simply no emergency that requires a temporary restraining order. Yesterday, Mr. DeVore gave a passionate argument on how the day-to-day deprivation of due process was an irreparable harm. And that's simply not true. Now, on rebuttal, Mr. DeVore is going to say, I've litigated this with Mr. Feeney a bunch of times. We've joked about carpooling to these hearings. I can't believe he would stand in front of you and say that an ongoing due process deprivation is not an irreparable harm. I can't believe he would say that. The problem with that is that the procedural posture in these very cases shows that this is not an irreparable harm. I'll use the 05 matter as an example. On September 24th, Judge Grunke ordered that the state parties be added. On October 1st, in the Lurkins case, the 5th District ruled that the state parties were necessary and that any order entered without their presence was void. If the very issues we've been litigating before you were teed up at that point in time. There were cases pending in Clinton County, 21 MR 89, Effingham County, 21 MR 140, Montgomery County, 21 MR 112, which is now 005, Macoupin County, 21 MR 91, which is now 002. All that needed to happen in any one of those cases was an amended complaint and seek a TRO with the state given notice. There would have been no delay for service. A TRO is notice only. I don't know that any of us here are here because of service. We all appeared because otherwise we would not have had our voices heard. So if in fact there was an irreparable harm, if the day-to-day alleged violation of due process was so serious that it warrants an extraordinary remedy from the court, a ruling before this case can even be fully litigated, this case would have been in the appellate court and decided in October. This case never needed 140 defendants. This case needed one defendant, the state parties. And if and only if the state parties were enjoined, did this case need one school district. I mean, counsel has said in his 383, 384 pleadings, has referenced in court, and the court has even referenced. What we need here is an appellate decision. We don't need a circus. We don't need 150 of us. We don't need a class. We need an appellate decision. And that was teed up and ready to go in the fall. All that needed to happen were those cases needed to be pressed forward by plaintiffs. Plaintiffs chose to voluntarily dismiss those cases so that they could sue 140 school districts. And that choice is not made in a vacuum. That choice is a tell that there is no day-to-day irreparable harm that needs to be enjoined. If there was, this matter would be decided and we would not be standing before you arguing it today. For those reasons, Your Honor, we think a TRO should not issue. Thank you.
Thank you.
Judge, while preliminarily I had suggested to Mr. Feeney we could do this all 6 at once, but given...
We tried, Your Honor.
I don't think it works, Judge.
Okay.
If that's okay with you.
Yes, go ahead.
You know, the one thing that Mr. Feeney didn't point out, he did point out that I've sued a lot of his school districts, and he made some arguments. What he didn't point out to you, Judge, that every time he's made those arguments, he's lost. Now, I was expecting to get into the balancing of the equities, and I think I'll wait on most of that because I know Mr. Verticchio will want to wail on that for a while later. But I thought it was ironic that Mr. Feeney points out in the balancing of the equities this federal liability that's so overwhelming that the court should consider that in balancing equities. Yet then 5 minutes later, he acknowledged to you that of all of his clients, many of them would likely, if the court were to say the state can't do this, but the inherent authority exists, that a lot of them likely wouldn't even require masking. But yet, balancing of the equities because of some nuanced federal liability argument should balance in favor of not entering a TRO, even though if you don't enter it, at least as to the school districts, a lot of them would, irrespective of this overwhelming liability that may exist, would still not have a masking policy. So that's all I'll say about balancing of the equities. I'll save it for later with Mr. Verticchio. The mask mandate, can we come back to it again, Judge? And you kind of pointed it out, and Mr. Feeney ran around in a circle. The court understands what we're asking. What we're asking is if children are going to be required to wear a mask, as a treatment, as a device, whatever you want to call it, that before it goes on them, they're given the right to due process. Doesn't mean that we're trying to say there's never going to be masks under any circumstance. Exclusion from school. Before a child can be said, hey, get out of here, they have the right to due process. Now, what Mr. Feeney is trying to point out, and when I'll get to you later, when I get into my final comments with Judge Tromper's very eloquent addressing of this issue, but Ms. Haggard pointed out, well, Judge, if you do that, the system might collapse. So what Mr. Feeney really wants to say to you, Judge, is if you do what the plaintiffs are asking, then before we can force mask or exclusion policies, we have to actually do something. That's what we're asking for. I don't care how many kids have to wear a mask in a school. My clients don't care. They're not asking about how many kids might be excluded. What they're saying is you can't arbitrarily do that without following the law. And I'll get into it later, but as Judge Tromper said, we didn't write the law. The law exists as we have it, and we have to deal with it. And again, I'm going to read it to you later, but what she says is if the people have to follow the law, guess who else has to follow it? Government. So we're not asking you to say that school districts can't require masks. We're not asking you to say that they can't exclude kids. We're asking you that before they do that, that they have to follow the procedures that the law has and not just disregard that law. Now, this issue of irreparable harm, I like that. Again, Mr. Feeney made the same argument today that he made in front of the other courts and was never successful. But to suggest to you that, on October 1st, once the 5th Appellate District said you had to add the state parties, that we could have been right back in front of that court in a month. He's wrong. Because let me tell you something, Judge. If I could have just replet it, adding the state parties, and been back in front of the 5th Appellate District in a month, I would have done it. You know why that was never going to happen? Because the state was never going to allow it. They would have filed a motion to consolidate in a moment on any case that was existing in the Southern Illinois if I would have done. I knew that. So we had to do what we did, which is work to consolidate them together. Yes, new people got added to the case. It eventually made it in front of a Supreme Court and made it in front of you because that procedure was going to happen no matter what. There was no way, I humbly suggest to you, ma'am, there was no way that Governor Pritzker was going to let me argue this case in front of a judge in the 4th Judicial Circuit in Southern Illinois and then end up in Mount Vernon in the appellate court. That wasn't going to happen. Because I promise you, ma'am, if that was possible, I would have done it. So the irreparable injury, we have not delayed anything. We have gotten in front of you as fast as we could get in front of you, notwithstanding requests to transfer the case to a different court in your building or motions for substitution of judge at the last minute. We got in front of you as fast as practically possible once the 5th Appellate District said that the governors and the state agencies were necessary parties. There was no delay. There was nothing to suggest that that somehow or another vitiates irreparable harm is an absurd proposition. I agree with Mr. Feeney, though, it needs to be in front of the appellate court. No doubts. Getting in front of them quickly, no doubts. We're there as fast as we could possibly get there. given, again, the Fifth Appellate's published decision. I disagreed with, but so be it. They made the decision. The irreparable harm is irreparable. Again, every day that goes by, where, as Mr. Gerber pointed out, and we'll get to maybe a little later, these emergency rules and the governor's orders that he issued, and I have them here for you. We'll talk about them later. Got all of them here, Judge. They started on August 30th of 2021, and they went through primarily September 17th of 2021. Every order that was issued saying that school districts couldn't do what they're doing. Okay? Those cases were all against school districts only. And if you don't think Mr. Feeney and Ms. Satterley, I think she might, I'm not sure she's here, didn't stand there and argue in front of those courts that, well, the governor's issued his executive order and ISB has issued this rule and IDPH has issued, they did. They lost. But then eventually, Mr. Berticchio has his chance to come in court and argue on behalf of those agencies. And I'm sure he has and he will. But ultimately, Judge, every one of those found that there was irreparable harm because you were doing things to children without them having any opportunity to object. None. Just take it. That's the issue, Judge. It's irreparable every day that goes by. And that's why that element has been satisfied. I'll come back to the balancing of the equities later, Judge. Thank you.
Hello.
Hello, good morning, Your Honor. Kathleen Gibbons on behalf of Valley View Community Unit School District 365. I also am just going to focus on a couple of the components that are necessary for a TRO. And I'll start with where Mr. DeVore ended, irreparable harm. The irreparable harm outlined in his TRO is not that children don't get to object to wearing a mask or being excluded for close contact. The irreparable harm he alleges is that they are excluded from school because they refuse to wear a mask, or they're excluded from school because they have been determined to be a close contact. However, there is not one iota of evidence inside that TRO or his complaint that names one student who actually suffered this. And as far as Valley View School District goes, there are no such children. As the affidavit from our superintendent, which is attached to our response, indicates, there has been no Valley View student who has been asked to leave school because they have refused to wear a mask. And for our students who have been determined to be in close contact, they have access to e-learning, which actually allows them to participate the full school day with their classmates. They're just at home. So they have not lost a moments of education and instruction. The plaintiffs then pivoted regarding their irreparable harm the last time we were here with the filing of affidavits from a doctor. The defendants then filed affidavits from their doctors as to whether the CO2 and the oxygen of wearing a mask could cause irreparable harm. Again, we have no evidence of any students suffering any such malady. But Valley View School District stands here pretty much alone because we lost a 15-year-old athlete with no underlying health conditions within 72 hours of her being positive and showing the first symptoms for COVID. That, Your Honor, is irreparable harm. And that dovetails into the balancing of the equities. That the decision not to wear a mask and the decision to send a child to school who has been in close contact with somebody who has tested positive for COVID. I sat in a board meeting as a mother got up to explain that, as Mr. Gerber said, the statistics shows that often the children are not the ones who suffer the greatest harm from this pandemic. We had a mother share that her daughter got COVID and came into the house. Well, in that house was a grandfather who died from COVID. And now we have a child who has to bear that. That is irreparable harm in the balancing of the equities that go in. These decisions do not affect just these individual students and their parents. They affect all the rest of the children in Valley View, all the teachers, all the staff, and all the parents and other family members in those homes. That is the balancing of the equity during a pandemic. And then just finally, because I've sat here now for 2 days, regarding the likelihood of success on the merits and the due process arguments. Just very quickly, due process for students in school is a sliding scale. A child can be suspended up to 10 days under the school code, under federal and state law, and the only due process they get is a piece of paper that says Joey was fighting, so he's being suspended for 8 days. Here, when a child is excluded because of the pandemic for close contact, they actually are not being deprived of an education in Valley View. So I'm not sure what due process they're owed, but Valley View has notified the parents. It's notification. They have notified the parents. It has been published what the mask mandate is, what close contact is, how you access e-learning if you're positive with COVID or if you're a close contact. I am not sure what other due process in this scenario children would be entitled to. Thank you, Your Honor.
Thank you. Mr. DeVore, you or another attorney?
It won't take long, Judge.
All right.
I don't want to, I think it'll confuse the issues. Judge, my colleague again talked about the sliding scale of due process. And the example given was being suspended for some disciplinary issue. Judge, we're not talking about that. It's got nothing to do with what we're talking about. And again, talking about e-learning, how that's somehow another comparable to these children attending school. If we still need to have the conversation today that in-school learning is what children are entitled to, I mean, the statute itself talks about it mandates attendance days. Attendance days in the school is mandated by statute. And actually the provision where Dr. Ayala, I think, is the state superintendent, where she can actually go to remote learning and take attendance days away, that's what that statute does, Judge. It says when we have remote learning of a district, or state, etc., implemented by the superintendent, that does not impugn the attendance day requirements within the statute. So that right there says that e-learning in and of itself is not tantamount to being in school, because that's the whole purpose of that provision of the statute. And again, my colleague talks about, well, you know, children that may be a potential health risk because of close contact should be, you know, not being in the school because it can cause a potential detriment to other children. Again, I'm not going to do it now, but there's 2 paragraphs in that analysis that Judge Tromper did that does justice much more than I. Judge, what my colleague's leaving out is that there's a whole provision in the law that protects people from that. And again, if a child is a close contact and could potentially be a health risk, do any of us in this building want that child in the school? The answer is no, we don't. But the question that we're posturing to you is that the school district can't just decide that child's a close contact, so you need to leave the school. The health department does that. The due process that my colleague talks about, Judge, it's in the law of how we do that. And again, Your Honor knows that exclusion from school is subject to that process because the rule, before they played their game with the emergency that I know you're going to review, specifically lays out exclusion from school. So obviously the legislature was protecting these children from not just being arbitrarily excluded from the school. There's a whole due process provision, Your Honor. And again, that due process provision by our legislature has deemed it adequate to protect the concerns that my colleague raises. They've deemed that adequate. What all of my colleagues, Judge, are trying to say to you, what they're all trying to say, and what Ms. Haggard pretty much said, is that We need to disregard all of that right now, because if we don't, we can't do the things that we want to do. And again, I'll leave you this and I'll get to it later. Judge Trumper addressed that and said, you know what? While I understand what you're saying, that's not what the law says, and it's not for me to change the law. It's for the legislature to change the law. So, thank you, ma'am.
Hello.
Good morning, Your Honor. James Petrangar on behalf of Glenview School District 34. Your Honor, I'll be arguing why plaintiffs lack a likelihood of success on the merits of claims in the Austin matter. And I'm specifically addressing the claims that are addressed in counts 10 and 11. In counts 10 and 11, plaintiffs seek an injunction from the court prohibiting school boards from independently and separately issuing mask orders and from excluding students who are identified as contacts in the event that the state's authority is stricken by Your Honor. Now, when we last met on January 5th, you heard an argument introduced by my colleague, Mr. Picorni, concerning the wide grant of authority. We've heard allusions to the inherent authority in the school code that vests school boards with the rights, the obligations, and the authority to operate their buildings. 10-22.10 of the school code empowers school boards with the control and supervision of schools. Now, earlier this morning, you heard Mr. DeVore ask the court, where is the express authority for school boards to engage in public health? A couple weeks ago, he made a proclamation that school boards are not in the business of public health, that that's a matter exclusively reserved for the Department of Public Health. Your Honor, that's not legally the case. The school code is replete with provisions authorizing school boards to engage in the practice of public health, certainly as it affects their students, their staff, and the greater school community. Section 10-21.11 of the school code expressly authorizes school boards to develop policies and adopt rules relating to the appropriate manner of managing children with chronic infectious diseases. That's, of course, why we're all here today. Section 27-8.1, subsection 3 of the school code squarely places school boards on the front lines of fighting infectious diseases by requiring them to obtain proof of immunizations against a list of infectious diseases promulgated by the Department of Public Health. And through their regulations, through the administrative code, the Department of Public Health has a list of those immunizations. But, Your Honor, that is the floor that is required of immunizations. We know that a school board's role in requiring those immunizations and freedom from infectious disease is not merely a ministerial act. They're not just carrying out the directives and the decisions of the Department of Public Health. And we know that because in section 27-8.1, subsection 1 of the school code, the legislature expressly stated, and I quote, additional health examinations of pupils may be required when deemed necessary by school authorities. Additional health examinations. Those are health examinations beyond that, which are required by the Department of Health. Now, the school code in section 27-8.1 doesn't define what a health examination is. But through regulation, the Department of Public Health has made that definition. I direct your Honor's attention to 77 Admin Code 665.120. Therein, health examinations are defined to include both, quote, physical examinations and, quote, protections from communicable disease. So it's an examination by a doctor or some other health official, and it's those measures necessary to ensure protections from disease. Now, Mr. DeVore has made a point to the court that we should be following the regulations of the Department of Public Health that existed before the pandemic, before the emergency regulations came into effect. These regulations predate the onset of COVID, Your Honor.
Okay.
School boards have had the authority to require health examinations by health officials of students and to ensure that students are free from communicable diseases through immunizations long before COVID became the pandemic that swept this country. Your Honor, Section 27-8.1, subsection 5, requires that if students don't obtain the necessary immunizations that are promulgated by the Department of Public Health or additionally required by a school district, they are to be excluded from the school. It's a mandatory obligation. They are to be excluded. And unlike provisions of the school code that talk about discipline of students when there's a violation of the student code of conduct, requiring whether it's a Goss hearing for a suspension or whether a full-blown expulsion hearing, there is nothing in section 27-8.1 requiring any kind of hearing to exclude students who lack those immunizations. None of the framework set forth in the school code requires the kind of due process that counsel is arguing school districts are to apply by virtue of the Public Health Act. The Department of Public Health Act stands independent and separate from the school code. Nowhere in that Department of Public Health Act does it extend its applications to school boards. Certainly not on the issue of the hearings that are required. And Your Honor, I submit to the court that if school officials had to go to court in order to exclude a student or require a student to wear a mask during this pandemic, our school officials would be in court every day. There is a practicality to this. And Illinois Supreme Court decisions are clear that laws are to be interpreted to avoid absurd results. Our superintendents, our principals, our school officials wouldn't be educating students. They'd be in court every day on issues concerning mass application of rule that are not unique to any one student. Moreover, Your Honor, school boards are expressly authorized in section 10-22.25B.
Say that one more time. 10-20.
22.25B.
Thank you.
To adopt uniform and dress code policies for students to, quote, prevent endangerment of student health or safety. That's what a mask is. It's part of the dress code. So if Your Honor strikes the governor's executive orders and decides that the state does not have the authority to issue the mandates that it has issued, I urge Your Honor, on behalf of my client and on behalf of school districts across the state, that the authority of school boards that is inherent in the school code, that does not contradict the express authority that I just outlined to this court, the authority of school boards to make their own local decisions on the issue of masks and exclusions for close contact must be preserved. Counts 10 and 11 and counsel's TRO as it applies to those counts should be rejected. I also want to make clear, Your Honor, that I'm not arguing that my client or any other school district is under any mandate in the school code to issue masks or exclusions. What they have is the discretion to decide what is right for them locally, what is right for their students based upon the data and the issues that are facing that school district. That's all.
Thank you.
Dress code policy, Judge? Are we really gonna go there?
There was a judge in Adams County a year and a half ago, but in his opinion, they could do it under the dress code policy. The only one that I'm aware of. Actually, I think it's 11 times I've argued this issue since August 30th. None of my colleagues brought that up. But I would hope, however this court rules, that it doesn't say that a school has an inherent authority under their dress code policy to require devices intended to limit the spread of an infectious disease. I hope it doesn't go there, Judge. That is a stretch beyond which I think anybody would be willing to accept. Do they have the authority to enter into public health types of matters? You can decide that. We're arguing they don't. It's not a dress code issue, Judge. I'll move on from that. Now, they keep coming back to TIT-21.11. Most of my colleagues do. It's like if one more of them gets up and says that, maybe the court would use it. I'm going, the word with, W-I-T-H, with chronic infectious diseases. What the statute says. Judge, we are not talking about children with chronic infectious diseases. We are not talking about children with chronic infectious diseases. Can we move on from that? Please. Now, this issue about Section 8.1, I like Section 8.1. To me, it actually stands for the proposition that what they're doing, at least as it relates to exclusion, beyond their authority. The legislature crafted a specific statutory section on physical examination, which includes vaccination. We have a whole list of vaccinations Department of Health requires. My children had them. Heck, I probably had them. I don't know how old this law is, but I probably did. And it says, guess what it says in there, Judge? It says if children don't have these vaccinations, and they don't, again, we're going to set aside whether they have a religious or a medical exemption. That's not for this conversation. If they don't have them, guess what authority we as the legislature give the school districts? You can exclude the children. They granted it to them expressly as it relates to that issue, Judge. But they're in here trying to tell you under some other, really they try to say this, but under either other general vague provisions, we can exclude children from the school building if they don't put a mask on or if we think they're a close contact. This provision of the law says under these facts you can exclude. If the legislature is granting them authority to exclude under certain circumstances, that's fine with me. I don't have a problem with that. It cuts against their argument that they otherwise can exclude children for reasons they think are sufficient. Absolutely cuts against it, Judge. They point to, again, that part of the Department of Public Health Administrative Code, Section 665.120. Again, Judge, we have specific provisions in the Public Health Code dealing with what schools have to do, and I'm okay with that too. What we don't have is anything in the Public Health Code that deals with allowing school districts to do the things they're wanting to do in your courtroom today, mass exclusion. It's not in here. But it says health examinations requirements, that's the caption, health examinations for public, private, independent, and parochial schools in Illinois shall require a physical examination. Okay with that. In accordance with the timetable set under another provision and protection from communicable diseases. What they're saying, Judge, is that school districts shall have health examinations for the purpose of other things trying to prevent communicable diseases. There's nothing wrong with that. There's nothing in that provision about mandating examinations to say that that includes the utilization of a device intended to limit the spread of an infectious disease. It's a completely different conversation. It's a completely different conversation. This case, Judge, gets real easy if the court, when it's looking at our count that says this emergency rule adopted by the Department of Public Health on September 17th, the same day that we really ended this run of circuit court cases using these provisions to strike down school policies. It says in there exclusion from school. The type of quarantine. Because what it says, Judge, in the rule, that quarantine also includes modified quarantine. So modified quarantine is not a separate subpart of quarantine. They are, in fact, quarantines. That's what the rule says. And it lists it in there. Exclusion from school. Now, they're in here now trying to argue, well, that's not covered under the Department of Public Health Act. Like, they don't want to pretend that the governor and the agencies tried to strip it out, so we don't have to talk about it anymore. And again, obviously it's covered, Judge, because it's specifically in there. A device intended to limit the spread of an infectious disease. Is this one of those? Of course it is. Judge, of course it is. Those are covered under the law. Now, again, my colleague once again brings it up, and I'm not insensitive to it, and not a judge that I'll talk about later was insensitive to it, Judge. The practicalities. Well, our school districts would be in court all day. No, they wouldn't. Because it's not their obligation, it's not their responsibility, it's not their delegated authority under the law, it's the health department. Maybe if we took some of these $1 billion of ESSER funds, instead of doing whatever they've done with them, and actually we used that money to bolster our health department over the last 2 years, they could have followed the law. This is not a school district's responsibility. That's what Judge Tromper spent 2 pages, and I'm going to talk to you about later. It's not their burden. And she was appreciated that the governor and these agencies are trying to place that burden on the school districts. That's what they're trying to do. And I would suggest to you humbly they're trying to place it on the school district because it gives them the ability to try to work around the Department of Public Health Act. But that doesn't really matter. But again, Judge, it's not their burden under the law. As I read to you yesterday, where the Department of Health delegated its authority to the certified local health departments, it said in there for the purpose of having the immediate ability to respond to matters of, again, vaccination, testing, quarantine, isolation. We give local health departments this power that the legislature gave to the state then gave it to the certified local health departments. So it's their obligation to manage these things. It's their obligation. Trying to put that on school districts, it's not fair to them, and I'm okay with that. But the school districts can't stand in here and you and say, Judge, disregard all of these provisions in the law because it creates a practical problem for us. It's not their problem, Judge. It's not their problem. Does it say that they have to work with the health departments? Yes, if you go under the Illinois, or I've got my computer here now, administrative code, under 690.30, it actually says that the school district need to work with the health departments. But the burden is on the health department, Judge. The burden's on the health department. That's why State's Attorney Wright and I stood on September 3rd in this building arguing the issue. And guess what happened? An order of quarantine, I've got it for you later, an order of quarantine was entered by the court. Saying, child, you can't go to school. Child, you have to wear a mask. It worked the way that the law says it's supposed to work. And they want to say to you, well, Judge, but as Ms. Haggard said, it's going to break down. One, I disagree that it would break down. And two, that's the provisions the legislature put in place for us as citizens and for the court to follow. And if these problems that my colleague stands here and says to you really are so overwhelming that the system will collapse, Judge, the legislature can fix it, and I've said it to you since I've started, in a heartbeat. If it's really a problem, and they're not just in here trying to scare the court, if it's really a problem, I would call on Governor Pritzker to convene the General Assembly, and they can fix it. They can take a shell bill. We all know what those are. They can throw it in there. They can have it through their supermajority in no time and sign it. Problem solved. That's the solution. The solution is not to ask this court to completely abandon the legislative acts that are in place right now.
Morning, Your Honor. Mallory Maluzzi on behalf of a number of school districts. I think what I wanted to emphasize very briefly is that this Department of Public Health Act, which is the procedures that Mr. DeVore is emphasizing that school districts must follow, is not the case. That school districts have their own concurrent authority as described by my colleague, and that the courts have recognized that there is other authority to require exclusions from school and even quarantine. And as one case specifically is Hagler versus Larner, L-A-R-N-E-R, 284 L 547 from 1918, which was during the smallpox epidemic, which was the last large pandemic this country has seen. And there was a local municipal Board of Health that passed a resolution requiring the temporary exclusion of any student who was potentially exposed to smallpox, so a close contact, from school for 10 days. And the Board of Health, the Department of Public Health there's multiple cases around that time about them entering and their, supreme authority to do quarantine and isolation. And the court still held that by the powers delegated in that case to a municipality, they had the authority to do this. They noted that it was a temporary exclusion, similar to the ones we're talking about here. It was for potential exposures of students, not students who were sick, and stated that it was an emergency situation of a pandemic. An emergency, in their definition, is when it was necessary or even apparently necessary to prevent the spread of smallpox and preserve public health. We're dealing with a very similar situation here, where the intent is to limit the spread of COVID in schools, and that masks and exclusions of people who have been in close contact with those who have tested positive COVID it would be apparently necessary to exclude them from wearing masks to prevent that spread. In previous times, there's been talk about this as supreme authority, which is very narrow and limited to isolation and quarantine, even in the statute. So masks would not apply, and I believe that the Attorney General is going to talk more about the definitions within that aspect as they apply to the Department of Health Act. But schools aren't required to follow due process requirements, as my colleagues have said, laid out in this act, because they have their own separate authority. So, thank you.
Thank you.
Judge, I don't have much on that. I'm quite familiar with Hagler v. Larner. That case is 104 years old. I've actually used it for certain arguments, but it's not for an argument here in this court today. There's been all kinds of statutory provisions put in place in the last century, including the ones that we're here arguing in front of today. So I like the Hagler v. Larner case, but again, it's not on point to the issues that we're talking about here. And as for the issues of isolation and quarantine, again, the statute's clear that the health department's the supreme authority, and what constitutes a quarantine or not a quarantine, again, the court's been well versed on what that is, and the court can decide that. I don't need to go any further.
All right, thank you. Besides this attorney, who do we have left besides Mr. Verticchio? Is that everyone? I've heard from you. Okay, we'll see where we are in time. This is what I'm going to propose. Because we're at the lunch hour, I would propose that we push through lunch and we end at 1. And then everyone can be on their way to drive home, deal with traffic, all that. Rather than break now and come back at 1:30. Does anyone have any objection to that?
It's not an objection, Your Honor. I'm not sure it's feasible to be done by 1, but I'm all for plowing through.
Well, I set this to go until noon.
I understand.
And I'm allowing an additional hour because of that. So let's see what we can get done in that time frame, okay?
I'm gonna be fast. Melanie Rankin for 2 of the districts, Homer Community Consolidated School District number 33C and Consolidated High School District number 230. I want to begin by apologizing for my mortifying phone incident. I want to apologize to you, Mr. DeVore, because you were actually arguing. But note to self, if you want to check a live stream to make sure that the cameras aren't showing your notes, it's going to play your audio too, even if it's on silent. So, and then your brain turns to scrambled eggs and you can't figure out how to turn it off. So,
I saw
anyway.
you scrambling, it's okay.
So, Judge, I just wanted to address a few of the questions that you actually brought up on the 5th that
Okay.
I feel like maybe you haven't gotten the answer, a complete answer to.
Okay.
So that's the only
Wonderful.
very focused reason that I'm here.
Okay.
First, you had raised the question a couple of times about, what difference does it make with the mask if you've got kids who are leaving the school, they're going out into the public anyway, and what good are the masks going to do?
Okay.
And my point there is that is actually the exact reason that masks and close contact quarantines are necessary, because if all of the staff and all of the students lived inside of the school and never left the school, we wouldn't have to worry about close contact quarantines. We wouldn't have to worry about masks because we wouldn't have to worry about anybody bringing germs in from the outside. But in this case, you've got students and staff who leave the school, they go to social gatherings, they go out to eat, they go to Target or what have you, and then they come back into the school because they have to be at school because they're either getting educated or doing their jobs. They're not necessarily they're not choosing to be at the school like they are the restaurants or the malls or anything like that. So, and to that end, it's not as if everybody in the school is created equally. You've got student A, for example, who may have an immune disorder or a heart condition, and student A's parents really have lived in a bubble for the past year and a half. They don't go to restaurants, they don't go to malls, they don't go to concerts or social gatherings. They haven't seen their family for a year and a half. Whereas student B, she's not immune compromised, she doesn't have any pre-existing conditions. Her parents, her family, rightfully, it's within their rights. They go to concerts, they go to social gatherings. Well, then student B comes into the school, and if she's not wearing a mask, she is exposing student A to all of those germs that she just was exposed to outside of the school. And even if student A is wearing a mask, it's undisputed from what I've seen and all of the medical studies, the scientific studies, that the double masking, the student A and student B wearing masks, is the ideal situation. That if student A is wearing a mask but student B isn't, student B still has a greater chance of transmitting the virus to student A than if she would if she were wearing a mask.
I know what you're saying.
Thank you. And but I also, just as a preliminary matter, wanted to make the point that I don't believe that that we are at a point in this case where we should be debating the effectiveness of masks. Not at the TRO stage. If we want to debate that, if we want to take that into consideration, then the parties should be able to cross-examine witnesses, cross-examine each other's experts, provide. So your second question, you had mentioned about, you had asked how can the districts argue that it's about masks being medical treatment versus when the FDA has declared them to be, I believe you referred to medical equipment, medical devices, and this is a critical point because people don't, we do have a right to refuse medical treatment, but medical treatment is not equivalent or interchangeable with medical equipment or medical devices. By definition, treatment is an action or a way of treating a patient for a condition, medically or surgically. So, a surgeon does not wear a mask to treat herself. She's wearing the mask to protect the patient from getting whatever virus or any germs that she's been exposed to. So it is not treatment in that regard. If you want to argue that it's treatment that, plaintiff wants to argue that it's treatment in the sense that it is providing a level of protection to the person wearing it, I would equate that to a Band-Aid in the sense that I think we can all agree we don't want students and staff walking around with bleeding, oozing, gaping wounds, and that those districts would be within their right to say, hey, put a Band-Aid on that, because we can't have bloodborne pathogens being spread all across the school. While the Band-Aid, maybe it helps the wound heal, so it might be serving a treatment purpose, the bigger picture, the reason for wanting or requiring the bandage is so that that student is not spreading a virus or a bloodborne pathogen to other students or staff in the school. So I just wanted to make that point. And then we had, along the lines of the constitutional, the due process argument, you had raised the question on the 5th about whether this is the least restrictive means, whether a close contact quarantine really is the least restrictive means if we're going under, the strict scrutiny analysis. And I would say, first of all, plaintiff concedes that the districts can, we all know, districts can exclude sick kids. We can argue that, we don't need to argue that. The question is, and plaintiffs keep arguing that these are not sick kids that we're excluding. But the problem is, with COVID, we don't always know when an individual is sick because they might not ever show symptoms. And they might test negative very early on while they're still contagious. For the first 5 days, they may be testing negative. And so it is a unique virus. That is why we have all of these new laws and it's unique. And to your point about the flu versus COVID, the flu is less contagious. It is not contagious for as long of a period of time as COVID. We can argue about the morbidity. I know that there's a lot of debate right now about whether the numbers are accurate coming from the hospitals, but I think it's fair to say, I would bet that most people in this room know somebody who has at least been hospitalized with COVID, if not has died from COVID. I can't say that about people with the flu. I don't know anybody who's been hospitalized with the flu, and I don't know anybody who's died from the flu. But in the 2 years COVID has been here, I can count on at least 2 hands the number of people I know who have become seriously ill from it. And so there is that difference. And so going back to your least restrictive means, it is the least restrictive means that I can think of, in the sense that they're not requiring vaccines. I think that if they were, we would have an even more packed courtroom than we would right now. And so vaccines are much more restrictive. Shutting the school down is much more restrictive. Requiring daily testing would be much more restrictive. Requiring students to completely remove themselves for, an entire semester or whatever if they've been exposed to COVID. The districts, the state are doing what they have found to be, what science has shown to date to be the least restrictive means to control this disease. And to the extent that plaintiffs keep arguing that the close contact quarantine is denying these kids an education. I know we've talked about this before. We've talked about the fact that they're entitled to virtual learning. You raised a concern that virtual learning doesn't provide the same quality of education. And in some instances, I think that's been proven accurate, maybe. But the bottom line is, in the very worst case scenario, you've got, even if virtual schooling was not an option for these kids who are quarantining for 10 days or 5 days or however long it is now under the CDC guidelines, even if they are excluded from school, that is not excluding them from an education, no more than when a school shuts down for a snow day for the safety of the kids. They're not saying, well, December 5th we were scheduled to learn our multiplication tables, but you don't get to learn them now. No, you just come back to school, you get your education. It just might be it might be packed into a shorter period of time. I'm sure any teacher who is attempting to do their job during this pandemic, I'm sure would be happy to tell you that they are not leaving these kids hanging out to dry. The kids are coming back, and the teachers are getting them caught up. They are providing that education. Schools have been sending homework home for, at least since I was a kid, when kids are sick. They send the homework home. I know when my son recently had COVID, they sent the homework home. So they're there to help the kids. So they're not being deprived of an education. They are simply.
At what point does individuals' right to in-person learning excuse me, at what point does that individual student's right to an in-person education, when does that due process right outweigh another individual's right to be free from germs? I mean, we have this balancing act here.
Right, but if
Because a student could be deemed a close contact and have to be excluded, only to come back and again be deemed a close contact and have to be excluded. So at what point do you understand what I'm asking?
I completely understand what you're asking. I would posit, though, that student A that we talked about earlier, with the heart condition, with the who's immune compromised, that individual would have to remove themselves permanently from school. No, it's not an if. It's not a
I
if
get
they're
what you're saying there.
exposed.
But what about, if that's the case, then why don't these individuals who have higher risk, why didn't the schools ever implement a mask mandate to protect them previously from other airborne diseases?
Because I believe, as I said before, because COVID has proven to be a completely unique new virus to this country. I mean, to the world. It's more contagious. It's contagious for the longest period of time. And perhaps the most dangerous thing about it is the fact that you can be asymptomatic and have it and spread it. And so, and then one more issue. I want to take issue with something Mr. DeVore said about how it's not the school district's problem if every student is afforded due process, or
I know what you're
that
saying. Yeah.
is completely disingenuous in the sense, I mean, ask the Chicago public schools, if it is not their problem that their teachers expect the public school, their employer to provide a safe environment. More importantly, to my client's point, which are really the small districts who don't have the resources that the larger districts do, it's a huge burden on them. In one sense, they don't have the staff to conduct all of these, the tracing, and they're trying to keep their students and their staff safe. But we go back to the school code that does grant the districts to the right to exercise their powers for maintenance and operation and development of schools, and to adopt and enforce all necessary rules for the management and governance of the schools. If you don't have teachers there to teach, how are you going to operate your school? And so these small districts, they don't have the pool of substitute teachers or the pool of staff who have, they've got perhaps 100 teachers who might have a conference hour at 6 hours that could pop in and sub for other teachers. These smaller districts don't have those resources. So if a wave hits their school, they have no way to operate. And so there is a huge burden on the school and it is their problem. It's their problem because they have to keep their staff healthy enough to teach, and the schools are absolutely responsible for the health and safety of their kids, of the students. So that is all I have.
Thank you.
Judge, a complete mischaracterization. When I said it's not the school's problem, what I'm saying is the problem of determining public health and dealing with quarantines and exclusions. It's not their burden under the law. Should it be their burden? I don't know. Everything 90% of what I just heard my colleague speaking to you about would serve her well standing on the floor of the General Assembly making arguments about policy on why we might want to change the law. Some of the things she said I might even agree with. We're in a courtroom, Judge, right in the legislature. My colleague said, well, over the course of talking about this novel coronavirus, all the new laws that we've seen as a result. What new laws? As it relates to this issue, I've seen all kinds of them. None of them dealing with the concerns we're standing here in front of the court today. I don't know what laws she's talking about, unless she's calling the executive orders and the guidance and these emergency rules laws. I would hope not. I mean, lay people across our state have been calling them laws for a long time. I would hope licensed attorneys are not suggesting that that information is laws, because it's not. I also heard talking about these various measures, the sliding scale of these different types of provisions. And I sat there thinking to myself about, because I think there was a suggestion, well, if we were talking about vaccines, we were talking about these more, let's call it intrusive measures, that sliding scale. Judge, I'm thinking of where we stand today and where we were in March of 2020 when I heard 2 weeks to flatten the curve. Where are we at now? Right? Where are we at now? So this sliding scale, again, even though it's not directly the issue in front of the court, that argument doesn't work 22 disaster proclamations in, Judge. Might have worked 1 or 2 or 3 or 4 in, but not 22. This conversation, again, coming back about masks and close contact quarantines. You know what I like, Judge, is when we started this off in July of 2021, they were using the term quarantine. We're using it. Specifically, schools were using it, Department of Health was using it, ISB was using it, they were all using it. Well, then we started winning cases, and then all of a sudden, well, we're not talking about quarantine anymore. They changed the term on exclusion from school. We're not talking about quarantine, we're talking about exclusion from school. That's not the same thing, they said. Well, then here I come again. I underline in the rules. Wait a second. It says right here, exclusion from school is a type of quarantine. Now what do? They're going, oh, they kept losing. Well, now all of a sudden we'll just create an emergency rule and we'll strip that out of definition. And so now exclusion from school is not a quarantine because it doesn't exist in the rule anymore. So they're moving the ball on that, Judge, and never once has any of my clients ever said that masking or quarantine because of a close contact determination is a problem. We've never said that's a problem, ever. It's about what does it take to get there to either one of those. And again, I'll come back to it again when we were in this building, September 3rd. That was it, Judge. We were on that topic, and I have it, and the court has it in the record. I've got it right here. It has my signature on it. It's got State's Attorney Dan Wright's signature on it. The case comes in front of the court on the petition for a court order authorizing quarantine. It's right here. Sangamon County Health Department, named plaintiff. The court ordered. And if the court's seen it ordered, you got to be excluded from school as a type of quarantine. Got to wear a mask. System worked. As I told you, I was in court last week arguing the same thing. They want you to strip that away. They want you to strip that away and say, you don't have to do any of this. I don't do this. We want to ask children, and we want to quarantine them, exclude them from the school, and just tell them nothing you can do about it. That's what they want to do. And they want to stand in front of you and argue the practical concerns they have about if you give my clients what they want, that this creates some kind of enormous burden on them. This court order right here. It worked. It didn't take weeks and months. State's Attorney Wright and I were in this courtroom for, not very long. This order was entered. Because guess what? The health department had determined in its professional opinion that my client's children, in their opinion, was a close contact to a positive case, and they needed to put these measures in place. Okay. It worked. It can work, Judge. And again, I'm going to say this over and over. If there is a practical concern, like some of my colleagues have raised or Ms. Haggard had raised, that's not for the court to get into and meddle. It's for the legislature to get in. Legislature wants to get into session, Judge, and put in a rule or a law, whatever you want to call it, that says school districts are given this authority during a public health emergency. You've seen it 10 or 12, 15 times in the school code. During those times when we have a public health emergency, put it in there. It says during these times, school districts are empowered to exclude children from the school if they determine that a child is a close contact following guidance from the health department. Or they can require kids to wear masks during these times of pandemic. Do it, and I'll walk in this courtroom and with a smile on my face like I said yesterday, and I'll dismiss this case. But until then, they shouldn't be coming in here asking you to disregard the law because they think it's convenient or necessary for the practicalities that they have. Because if that's how we govern ourselves, Judge, we will not recognize this nation or this state in another generation. We will govern ourselves based upon these practical concerns that they want to raise, and the rule of law will become nothing. Thank you.
Nancy, how are you? You need a break? Okay. Be sure.
Yes, Judge.
You've addressed me a lot.
I have, Judge. Robert Swain, and Judge, I want to be very short because Mr. Berticchio is not addressing the Yoki case, and I want to preserve time for him here.
Thanks.
I want to connect just a couple
He
of
hasn't
things.
addressed what?
He has not addressed the court in the O2 case, and I want to preserve time for him. I want to connect just a couple dots quickly. This argument Mr. DeVore is making about the legislature fixing the practical problem, as he thinks he sees it, the legislature fixed it, Judge. Section 2M of the Department of Public Health Act says that the quarantine and isolation provisions apply to orders issued by the department. That's the whole question. Whether the Department of Public Health hearing provisions apply to schools. But the Department of Public Health statute itself says it applies to the Department of Public Health orders. That's in Section 2M. That's what I asked Mr. DeVore just yesterday, and he declined politely, and Mr. Gerber brought it up today, and maybe he could address it. We also, when we were here a couple weeks ago, we discussed due process in some length. The point that Mr. DeVore conceded, it wasn't that it was a constitutional claim they were asserting a right to a statutory hearing. But the idea of constitutional rights has crept in quite back slowly, and Mr. Gerber, again, to be fair, who didn't make that same concession 2 weeks ago, full-on brought a constitutional argument before you this morning, to which I would respond with everything I said 2 weeks ago, and which I know you recall quite well.
I do.
Okay? 10-21.11, as Ms. Rankin actually just said quite well as well. It says, managing children with chronic infectious diseases. It doesn't say managing children with symptoms. And if anything, maybe that's really where to distill this down, our discussion is. Because if we all agree, and it sounds like we do, that schools can exclude children who are symptomatic, then we have to ask ourselves where that authority comes from. And it is that exact same authority that schools are using to submit children who are within an incubation period. Now, we can quibble, but I don't think it's for us to quibble in a court of law. I think it's for the health officials to determine how we, or which children who have been exposed in close contact, and maybe within an incubation period, which of those and for how long need to be treated as if they may have that chronic infectious disease. But with chronic infectious disease may also mean that incubation period. So this distills down to there, Judge.
I'm sorry, say that again?
So I think the issue distills down to.
Oh, distills, thank
Yes. Okay. We're using the exact same authority that we would use to exclude symptomatic kids. And finally, Judge, without getting ahead of ourselves, I want to make one last request, knowing that we're coming here to the end of our.
I want to stop
meetings.
you right there,
Of
though.
course.
If you're saying what you just said,
Yes.
then why does the school code reference the due process provisions in the Illinois in the Department of Public Health Administrative Code?
27-8.1?
Yeah.
Yes. It says when they do not have their vaccinations, then you must use that process. But we certainly can't infer from that every time a sick kid shows up to school with a runny nose or a cough or stomach flu, that we have to go through a Department of Public Health process. Or perhaps that is the logical end of their argument. That's the problem with their argument. That's the problem with their theory. We all agree that schools can exclude sick kids, but I think we have to think about what that authority is and then how it applies to kids who may be asymptomatic. That's really what we're talking about.
Okay.
And finally, I want to reserve time for Mr. Berticchio, from whom you've not heard in this case. But in the event, And you've heard a lot about the importance of local control. We've spoken a couple times about the contingencies and the difficulties schools have been going through. If you find it appropriate to structure any relief that's going to change the status quo for schools, even if it's.
Just go back
Of course, if you find it necessary, Judge, to structure any relief for the plaintiffs, even if it's just as to the state mandates, whether or not it even compromises that local control, I implore you to give schools 24 to 48 hours to implement changes to the status quo under which they've been living since last fall. They have contingencies, they need to finalize those, communicate them to staff, communicate them to parents, and implement them in an orderly fashion.
Okay.
And now I do for Mr. Vicky. Thank you for all your time this day, Judge.
Yes, thank you.
Can we do 5 minutes, Judge?
A break?
For not only,
I think we
not only
should.
for me and for you, but for Nancy.
Let's do that. Just a quick 5-minute break and then we'll finish up, okay? That's like my,
Me too.
That's what I did the last week.
They're 18. I have triplets. Oh, they're all in college. First year of college. It did for a while.
All right. Trying. Thank you. Have a seat.
Good morning here again, Judge.
78 degrees.
Oh, my goodness.
Whenever Nancy's ready, Mr. Verticchio.
Thank you, Your Honor. Thomas Verticchio for the Attorney General and the State Party Defense. Right in need of protection, likelihood of success on the merits, irreparable harm, inadequate remedy at law, and balancing the equities. It's an extraordinary remedy, Your Honor. The burden needs to be carried, and it wasn't. Protectable interest, likelihood of success. The plaintiff's theory, and it's been flushed out over a course of days, but the plaintiff's theory is that masking and close contact exclusion or quarantines or modified quarantines under the Illinois Department of Public Health Act that require the procedures set forth in Section 2 of the Act. There was some question when the plaintiff's pleadings were filed, the motions were filed, whether, well, is that the theory? And Mr. DeVore, to his credit, conceded the point yesterday, or I'm sorry, on January the 5th. Yes, that's the theory. That's the theory. We are not, in response to Mr. Swain's constitutional analysis, Mr. DeVore was very frank with the court. We're not seeking constitutional remedy. We're seeking the procedure set forth in a statute. So now we know that. It's not a constitutional claim. The theory fails for multiple reasons. Okay? And you began the proceedings on the 3rd of January asking about the emergency rules, suggesting, I believe, I think is a fair thing to say, suggesting that if the emergency rules weren't valid, then this kind of becomes easy. And then we just heard that same thing from Mr. DeVore not 10 minutes ago. The case is real easy if the emergency rules aren't valid. It's real easy. It concerned me when you said it, Your Honor, and it concerned me when Mr. DeVore said it, because it's simply not true. The plaintiff's case fails regardless of the emergency rules on multiple grounds. And what's critical is that the multiple grounds are independent of one another. First, the plaintiff's claim fails if the governor had independent constitutional authority to issue the executive orders.
Okay.
If he had independent constitutional authority to issue those orders, then they stand, regardless of the emergency rules. So it's not so easy. The executive orders themselves all say they're issued pursuant to the governor's authority under the Constitution. Now, we briefed this issue, Your Honor, and we talked about it at some length on the 3rd of January when we were discussing the Allen case. There's no need to go into the details of the constitutional authority. Suffice it to say, it exists under the Jacobson analysis of cases, which analyzes a federal view of this. It's at pages 11 through 13 of our TRO opposition, Your Honor, the Jacobson case.
Okay.
And Mr. DeVore said yesterday, well, the state parties, they don't like Jacobson so much anymore because they finally realized that the measures undertaken in Jacobson were statutory. Well, that's true. But in the world of COVID-19, courts across the country have applied the Jacobson analysis, the Jacobson public health analysis to executive power, executive authority by governors across the state. And as I commented on a case yesterday, you don't have to go very, very far to look for those cases because one of the authors of one of the opinions is you. In the Hudsonville case, you laid out very clearly there is separate federal constitutional authority. You cited and relied upon Jacobson. But just to drive home the point, Your Honor, if you look at footnote 17 of in the TRO opposition to the Austin Hughes matter, you will see cases from around the country, several from federal district courts in Illinois and the Seventh Circuit, applying Jacobson to executive authority.
Okay.
There's also separate state constitutional authority for Governor Pritzker. And again, in Hudsonville, this is at page 14 of our memorandum, Your Honor, and the cases cited therein. But again, you don't have to look very far because you are the authors of, or are the author of one of the opinions. Hudsonville, you laid out specifically Governor Pritzker's state constitutional authority to issue mask mandates in schools. Mask mandates in schools. Sounds familiar? Yes, it's an issue today. Judge Anderson, and I think you even commented at one point in the Hudsonville proceedings, Your Honor, that Judge Anderson's opinion in the circuit court in the JL Properties case was a scholarly opinion. And he marched through the Illinois constitutional authority on this issue. It's Exhibit 8 to our memorandum, Your Honor. Here's what he said. He's quoting Illinois Supreme Court opinions. Quote, this is at page 14 of his opinion. There are few, if any, interests more essential to a stable society than the health and safety of its members. Toward that end, the state has a compelling interest in protecting and promoting public health, and here in adopting measures reasonably designed to prevent the spread of disease. Close quote. He was quoting People versus Adams, the Illinois Supreme Court. He quoted the Spillertown case from the Illinois Supreme Court. Quote, it has often been said that the most important of the police powers is the preservation of the health and safety of the citizens of the community. Close quote. The constitutional authority exists. How do we know that? Well, the General Assembly told us. The Emergency Management Agency Act, specifically Section 3D, Section 3. Limitations, quote, nothing in this act shall be construed to, subsection D, limit, modify, or abridge the authority of the governor to, then it continues, exercise any other powers vested in the governor under the Constitution. statutes, common law of this state, comma, independent of or in conjunction with any provision of this act. The General Assembly told us nothing in the Emergency Act is intended to limit, modify, or abridge the governor's independent constitutional authority. That's what he did in the executive orders. So where does the Public Health Act fit into this? Well, the short answer is, it doesn't. And how do we know that? Well, it was constitutional authority, but if you look at the Public Health Act, I've commented to you on this before, but the first job I ever had in this business, my boss told me, if the case is about a statute, read the statute. Well, I read the statute. The Public Health Act, in every provision that Mr. DeVore relies upon, has two critical words. And it's in B, C, D, E, F, every one that he says is triggered. And the words are the, capital D, department. The Public Health Act concerns orders of quarantine, isolation, you could talk about testing, you could talk about vaccines, and every sub-paragraph of Section 2, which is the entire premise of this case, says it applies to orders issued by the department. The executive orders were not issued by the department. And as Mr. Swain just pointed out to you, as if it weren't clear enough, the General Assembly wanting to make sure that we got it. We want you to know it's the department's orders that this act is concerned with. They decided to repeat themselves a bit. Subparagraph M, Section 2, paragraph M of the Department of Public Health Act. The second sentence, quote, the individual provisions of subsections A through H of this, capital S, section apply to any order issued by the department under this section, period, close quote. The orders that we're talking about where procedural protections trigger for folks emanate from orders issued by the department. You can look at the complaint, Your Honor. You can look at the entire record of this case, Your Honor, and you will find one order issued by the department. And Mr. DeVore, may I?
Absolutely.
Just showed it to you. It was in this courthouse. The state's attorney of Sangamon County represented the department, and an order was issued. And guess what? It followed the provisions of Section 2 of the Public Health Act because it was issued by the department. The people that were respondents to this order, case number 21 MR 1175, had every right under the law of this state to anticipate and expect the procedures under the Public Health Act because the Department of Public Health initiated the proceeding. That's not true with any executive order. It's not true with any action in this case. Section 2 doesn't apply. There was constitutional, separate and independent constitutional authority for the governor's executive orders on masking and close contact exclusion. Because of that, and because of that alone, the claim fails. It doesn't matter whether there was other statutory authority under the Emergency Management Act. It doesn't matter whether the emergency rules are valid or invalid. It doesn't matter. The constitutional authority existed. It was exercised. The case law could not be more clear. You yourself have written about the issue. The case also fails because there is separate, independent statutory authority for the executive orders on masking and exclusions of close contacts. The Illinois Emergency Management Agency Act bestows powers to the governor in the event of a disaster. Mr. DeVore told you earlier today, and this has been a theme throughout these 4 days, the General Assembly just needs to fix it. If they would just fix it, Mr. DeVore tells you, I'll walk in here with a smile on my face and dismiss this case. To which I say, fix what? They have a statute in place. The General Assembly, in its wisdom, decades ago, foresaw in the events of disaster, emergency powers are to be given and exercised by the executive. And by the way, I said they had foresight. It's not as if they were the only ones to think of it. Virtually every other state has the same kind of emergency disaster statutory scheme. Here, it's discussed in our brief in detail, Your Honor, at pages 14 through 16, but we've already touched upon it. It's Section 7, which has the emergency powers, subsections 8 and 12. They apply here. You and I talked briefly about occupancy. How does it apply to occupancy? Well, Section 7.8 says the governor has authority to control the occupancy of premises. And you and I had an exchange, I believe it was on the 3rd, in the Allen case. Who comes in and who can go out, who can go in and who comes out is controlling the occupancy. And Mr. DeVore took issue with that, saying, no, occupancy in landlord-tenant law, but that's not the analysis.
How does that section apply to masking though?
Because if you're not masked, you're excluded.
Okay.
If you're determined to be a close contact, you're excluded. And I looked quickly, Your Honor, but it's at footnote 22 of our brief. There's many cases on this. I'm going to quote to you the Family Vision Care case. Quote, courts are to give the statutory language its plain, ordinary, and popularly understood meaning, and afford the statutory language the fullest rather than the narrowest possible meaning to which it is susceptible, period, close quote. The plain and ordinary dictionary meaning of occupancy, also in the footnote, quote, the condition of being occupied, as in occupancy by more than 400 persons is unlawful, close quote. As in occupancy by those who are not masked in a school is unlawful. Section 7, 8, and 12 gives the governor the authority, the independent statutory authority. And again, what's the role of the Public Health Act here? None. There's no order issued under the Public Health Act. If you look at the Public Health Act, every subsection that Mr. DeVore talks about requires action by the department with a capital D, and none of it is here.
I want to talk to you about section 12, because you cited that. So
Yes, that's the catch-all section.
Yes. So, if that is what section 12 was meant to be, the catch-all, then why do we have all the other prior sections above it? Because he could have just put section 12 in there and said,
It's a common statutory mechanism, Your Honor. I didn't draft the statute, but it's certainly common. I mean, I don't have to tell you. You've read as many or more statutes than I have, and they are typically 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, and that's all we can think of, so let's add 11 with some general language. I mean, that's how General Assemblies work, and that's what they did here.
well, let me ask you this then. If that paragraph is all-inclusive, because I have my notes here, and implies the governor's powers are endless, then why instruct the state agencies to promulgate rules to effectuate his mandates? Why not just say, section 12, you gotta do this?
Well, actually, the General Assembly anticipated that question,
Okay.
and specifically said in section 19. I've said this before in this courtroom and in others. This is not a haphazard statute. It's actually well thought out. Section 19, quote, in carrying out the provisions of this act, the governor, and it continues, is directed to utilize the services, equipment, supplies, and facilities of existing departments, offices, and agencies of this state.
Okay.
The governor is directed to do that. Well, that's half of the equation. What's the other half? Section 19. Those, quote, agencies are directed upon request to cooperate with and extend such services and facilities to the governor. And that's exactly what happened here. And that's why, when you look at the executive order, you will see that the governor makes requests and directions to agencies of this state, most commonly the Illinois Department of Public Health, and it is specifically within Section 19. And
But
what
I'm gonna challenge you, because we're gonna, again, get down to semantics. We talked about this with the words yesterday. Section 12, there's a semicolon there. You see that first sentence? Restrict, regulate, clothing, commodities, materials, goods, or services, semicolon. And perform and exercise any other functions, powers, and duties as may be necessary to promote and secure the safety and protection of the civilian population. Pertains to safety, not to health. Isn't there a distinction there because of that semicolon?
I don't think there is, given the breadth of the language, but more importantly, the specific provision in Section 7, subparagraph 8 would control, because we're talking about the occupancy of the schools. There's really, unless you were to demand upon the General Assembly to micromanage and have foresight to micromanage this to an extent that's really beyond comprehension. Section 7(8) that says control the occupancy of the premises within the disaster area certainly applies to controlling the occupancy of the schools. And in the executive orders themselves, Your Honor, the governor specifically references the need to control the occupancy of school to keep them safe. Straight out of the statute. And how do we know that the Public Health Act doesn't impinge upon, or could not somehow inadvertently impinge upon, even though the department wasn't involved in the issuing an order? Again, because the legislature told us so. The Department of Public Health Act, Section 2(m), the very end of the section, Your Honor, subsection. Nothing in this section shall supersede, and then the end of the paragraph, or sentence, procedures established pursuant to IEMA statutes. Well, there's no serious debate that the procedures we're talking about in terms of the statutory authority weren't established pursuant to the IEMA statutes. And when I raised this point on January the 3rd, Mr. DeVore said, wait a minute, that can't be. If you look at higher up in the paragraph, it's referring to chemical, radiological, or nuclear agents and events. Well, that sentence does. But the sentence that makes it clear from the General Assembly that nothing that the Public Health Department does in Section 2 shall supersede procedures in the IEMA statute. Use careful language, careful grammar, careful, to be precise, capitalization. Nothing in this section. This section is Section 2. Section 2A, Section 2B, Section 2C, and on and on and on, all the way through M.
That was my question.
Well, and
Is
how do
your
we know
position?
that?
It's
How
all
do we know
or
that?
just M?
How do we know that? Because you only have to go a little bit further up in the paragraph
Okay.
where it says,
A through H.
no, it says, act for chemical, radiological, or nuclear agents or events as authorized in small case s, subsection M. When they refer to a subsection, they have the wisdom to say it's a subsection. Small case, subsection M. When they're referring to the entirety of the section, they have the wisdom to use a capital S section, and that's exactly what they did in subsection M, and it's true elsewhere. For example, if you look, Your Honor, at subsection B, one of Mr. DeVore's favorites. Subject to the provisions of subsection C. When they mean a subsection, they say a subsection. And the General Assembly could not have been more clear that nothing in Section 2, the entirety of Section 2 of the Public Health Act, the entire linchpin of the plaintiff's theory, nothing in subsection 2 shall supersede procedures under the Emergency Management Agency Act. The legislature told us. We know the governor has independent authority under the Emergency Act, and in the incredibly unfortunate and sad situation where disaster exists, we have given him authority to exercise emergency powers. And we're making it very clear right now that nothing in the Public Health Act supersedes the governor's emergency authority under the IEMA statute. And we know it because the legislature told us so. Independent authority under the statute, the Emergency Management Agency Act. And if you remember, Your Honor, every one of the executive orders says, I'm issuing this order as under my authority under two things, the Constitution and the Emergency Management Agency Act. That independent authority alone defeats the plaintiff's claims. And it doesn't matter whether he had constitutional authority, he did. And it doesn't matter whether the emergency rules are valid or not, because the independent statutory authority exists. This is, despite that, Mr. DeVore's view and the theory of the plaintiffs in this case is that, wait a minute, Section 2 says we have procedural rights. Section 2 says I get a written notice from the health department. Section 2 says within 48 hours I have to get notice of a court hearing. Section 2 says I have the right to a lawyer. Section 2 says, it goes on and on and on. I mean, the procedures are there, it's undeniable. The problem is they don't trigger because the department didn't issue an order of quarantine to anyone, except, in the record of this case, 21 MR 1175 in Sangamon County. It's similar, Your Honor. Now you've told us on occasion about your schedule, about you have felony trials on certain weeks. It's similar to the Code of Criminal Procedure. The Code of Criminal Procedure undeniably bestows rights. It just does. It bestows rights on people. But when does it trigger? It triggers when the charging authority, either the state's attorney or sometimes the police department, triggers the statute. And when the statute is triggered, those rights follow. Just like Section 2 of the Public Health Act bestows rights. But when do they trigger? They trigger when the charging authority, the Department of Public Health or the local health department, initiates an action. That hasn't happened.
Well, let me ask you this then. If you're saying that the governor has unlimited authority under IEMA, then can he issue another lockdown without any input from the Department of Public Health?
I'm not saying he has unlimited authority.
Okay.
I'm saying that the statute provides broad emergency authorities. And this court demonstrates the proposition that if people think it went too far, then the course of action is to bring a constitutional claim that the action went too far. And then that would be squarely placed on your bench. And you would decide. That hasn't happened here. It hasn't happened. So, yes, hypothetically, could a governor go too far such that a constitutional right has been deprived? I think hypothetically, of course.
Yeah.
Not with regard to masks. We've given you the cases all over the country, masking. it's not a constitutional deprivation. And there haven't been many exclusion cases, but the same follows.
Okay.
So, for those two reasons alone, constitutional authority, separate statutory authority, the claims fail.
Okay.
They also fail because under the emergency rules, the basis for the plaintiff's claims no longer exist. Here's what the law provides today and has since September 17th. Title 77, Illinois Administrative Code, Section 690.361, paren, small d, close paren, paren 1, close paren, paren, capital D, close paren. This will shock no one, but here's what the law provides today. Quote, for the purposes of this section, exclude means a school's obligation to refuse admittance to the school premises, extracurricular events, and any other event organized by the school, regardless of whether an isolation or quarantine order issued by a local health department has expired or has not been issued, period. Exclusion from a school shall not be considered isolation or quarantine. Then in section 690.361, paren, small d, close paren, 6, close paren, paren 6, close paren, the Illinois Administrative Code provides requiring testing or the wearing of masks or excluding a student consistent with this subsection shall not constitute isolation or quarantine under the Act 20 ILCS 2305/1.1 et sec, and may be done without order of court or order of local health authority. Now, I hope, particularly since the definition of modified quarantine was stricken at the same time, it doesn't exist anymore. I hope we can agree that if those provisions are valid, the claims fail. They must. If the provisions are valid, for that independent reason, the claims fail. Because masking, and as far as Allen goes, testing and masking and exclusion is not a quarantine, and the whole concept of modified quarantine doesn't even exist anymore. So then the question becomes, well, are they valid? Well, let's look at the law. The Administrative Procedures Act, Section 5-45, Emergency Rulemaking, subsection A, quote,
I might have this. Hold on, please.
We're going to do it visually and orally, Your Honor.
I
so
just
we're
held
really
space
gonna...
all along, sorry.
No. Thank you.
Maybe I didn't print that out, maybe that's on my desk. All right, go ahead, I think that's still on my desk.
I think you've referred to it before.
Okay.
Subsection A, emergency means the existence of any situation that an agency finds reasonably constitutes a threat to the public interest, safety, or welfare, period. Subsection B, if any agency finds that an emergency exists that requires adoption of a rule upon fewer days than is required by section 5-40 and states in writing its reasons for that finding,
Yes.
the agency may adopt an emergency rule without prior notice or hearing upon the filing of the notice of emergency rulemaking with the Secretary of State under section 5-70, close quote, and then the paragraph continues. You had some questions on, I believe it was the 3rd of January, what was the reason in the rule that they filed, and then we made part of the record
Right.
the actual delivery to the Secretary of State on September 17th. We subsequently filed that notice in all the cases, Your Honor. So I think that issue's aside. Yes, the reason for the emergency was stated within the emergency rule, and it generally says that I'm quoting this part, these emergency amendments are adopted in response to Governor J.B. Pritzker's gubernatorial disaster proclamations. Then it lists what it relates to. And then at the end, quote, the COVID-19 outbreak in Illinois is a significant public crisis that warrants these emergency rules, period, close quote. So the reason is there. It's in the Secretary of State filing that we gave you. It's actually even attached as Exhibit C to the Austin complaint. And we've given you the law on, I'm just quoting the Champaign-Urbana case, quote, the existence of an emergency is primarily a matter of agency discretion, period, close quote. But you asked, and rightfully so, you asked, well, why September? What was going on in September? Because I think your phrase was, this had been going on a long time, and indeed it had, longer than any of us ever thought it would, or even more importantly, wished it would. The easy answer is COVID-19 is a difficult target, and it keeps moving, and it requires fluid procedures and mitigations to deal with that moving target. But you wanted, and if you look at DO 24 and 25, now since supplanted by the January executive order, they mentioned this. They mentioned what's going on in schools. I'm looking at, for example, Your Honor, EO 25, the September 17 order. The whereas clauses in great detail talk about the health situation current in Illinois, and then the fourth whereas from the bottom details what's going on in schools. And then the second to last whereas clause, quote, whereas controlling the occupancy and restricting presence of individuals confirmed or suspected to be infected, and then continues with importance of the classroom. So the emergency rules themselves also lay this out. But what else was going on? Well, the record in this case, it tells you what was going on. We cited or filed in one of the supplemental filings the September 23rd declaration of Dr. Bleasdale. We had filed that in the Cornaya case when at the time it was pending in Kane County in response to a TRO effort there. That affidavit is now part of this case, and frankly, Your Honor, it was in direct response. We filed in direct response to your inquiry. Well, what was going on? Well, it was on September 23rd, so it's a few days later, but for our purposes, the important part of Dr. Bleasdale's information, and Mr. Gerber will find this interesting because much to my dismay, he made light of it in his presentation. But paragraph 22, from July 3, 2021 to September 18, 2021, the case rate for those under 20. So we're talking about school children, under 20, because that's where IDPH has its break, has increased from 17 per 100,000 to 241 per 100,000. Now that's still a small percentage, but where is this going? By my math, I did the calculation last night, Your Honor, that's an increase of 1,317%. So that's what's going on in September. And how else do we know that things were getting a little worse in September? The Illinois Supreme Court, they told us. Exhibit 12 to our opposition for the TRO is the Illinois Supreme Court's order of September 2, 2021. And it seems like when you look at it quickly, it appears as if it's just a rolling over of the order. Because the order, I'm reading the first operative paragraph, quote, it is hereby ordered effective immediately and until the further order of the court, that paragraph F of the court's March 17, 2020 order as amended on August 27, 2020 and May 27, 2021 is further amended as follows. So it's kind of like, yeah, there's nothing new here until you read it. The next sentence, paren, new material is underscored and deleted material is struck through. This order deals with masking in courthouses. Masking in courthouses. And the strike-through language from the Illinois Supreme Court in September of 2021, the same time of the emergency rules, the strike-through language, so the deleted language in September. Quote, pursuant to the current CDC guidance, courts may choose not to apply the provisions of this paragraph F concerning masking to persons who have been vaccinated against COVID-19 and are 2 weeks past their final vaccine injection, period, close quote. So prior to September 2021, the Illinois Supreme Court's order said, court, if you want, you can ignore the requirement of masking in courthouses. You can ignore paragraph F1 that says people that don't wear masks don't get in. You can ignore it. In September of 2021, the Supreme Court said, Delta's here, numbers are rising, we're striking that option. You, courts around this state, can no longer ignore the mask mandate. You are required to enforce it. And people that don't wear masks don't get in the courthouse. That changed in September, and that too answers your question about what was going on. And then we also, Your Honor, I made a point of it and you made fun of me, I think. Exhibit 5 to our opposition, it was 496 pages. You remember now.
I've looked at it, yes.
Yeah, you remember. I didn't. So, 6 agencies around this state, including ISB, of course, but then the Financial and Professional Regulations, Housing Development, Human Services, and the Department of Public Health. 6 agencies, 16 emergency rules in September of 2021 across societal bounds, dealing with issues across. It's not as if, it is not as painted by the plaintiffs. Hey, there were some TROs. Let's do an emergency rule. We've just given you Dr. Bleasdale's declaration about what was happening in September. We've given you the Illinois Supreme Court's decision to time out. Masks have to happen now. The executive orders themselves and emergency orders across societal bounds. That gives the record, and frankly, the only record, of what was happening.
Let me ask you this though before you
Yes,
move on
ma'am.
to your next point. So AIMA, it states that AIMA shall, play specifics on our words again, AIMA shall coordinate with the Illinois Department of Public Health regarding health emergencies. Would you agree it does not delegate the sole authority to the governor?
I'm sorry, Your Honor, what section of the statute are you looking
Oh,
at?
you're gonna make me look it up.
I'm sorry. If you can't find it, Your Honor, I believe the simple answer is that's exactly what he did.
Well, I have this highlighted. Let me. The Illinois Emergency Management Agency shall, so I'm under F. I'm under, section 5.
Section 5.
And F 2.6. I don't outline the parentheses as well. So it is 3305/5, open paren F, close paren, open paren 2.6, close paren. Coordinate with the Department of Public Health with respect to planning and for responding to public health emergencies.
Yeah, I mean, that section deals with, I think it's E, I think it's E, Your Honor, not F. But in any event, the 2.6, coordinate with the department. That's dealing with the Emergency Management Agency, a separate agency of this state.
Right.
When the governor is issuing his various executive orders on all kinds of subjects. I mean,
Right.
It's not just schools or masking. That a critical component of those is the carrying out by the Emergency Management Agency, the agency itself. And the General Assembly said, hey, agency, coordinate your efforts with IDPH. Makes perfect sense. But you then questioned, and again, rightfully so, you seemed uneasy with this notion. You can just do an emergency rule and that's that. Well, because I think you even said, where's the legislative oversight?
Mm-hmm.
It's in the statute. It's in the statute. The Administrative Procedures Act. This is 5 ILCS 100/5-120, dealing with, quote, responsibilities of the Joint Committee with respect to emergency, peremptory, or other existing rules. And as you know, you referred to it, that's JCAR.
Right, yep.
The statute goes in great detail what JCAR's, to use the General Assembly's phrasing, responsibilities are. Subsection A, quote, the Joint Committee may examine any rule to determine whether the rule is within the statutory authority upon which it is based and whether the rule is in proper form. Subsection B, if the Joint Committee objects to the rule, it shall, within 5 days of the objection, certify those facts, and then it goes on and on. And it goes on to say that if the agency rejects the objection, then the Joint Committee has the power, under section 5-125, the very next section, to withdraw the rule. And then upon that, the rule is no further effect. There is a direct oversight of JCAR, obligation to oversee emergency rulemaking by JCAR, examine the rule, object to the rule if it's improper. And if the agency says, nah, we're not listening to that, then make the rule ineffective, and it's immediate. So the legislative oversight is there, and what do we know? None of that happened. There's been no objection to the emergency rule. There's certainly been no rejection by the agency to a JCAR objection. And there's certainly been no demand that the rule be withdrawn and have no further immediate effect. The legislative oversight is there. None of that happened. Where does that leave us with the emergency rule? Because there is one thing that Mr. DeVore has spoken to you about, rightfully so. May I approach, Your Honor?
Yes.
You already have it, but I feel like you need more paper.
Thank you.
You got it too, Tom. I figured that's where you were going. Judge Trumper's order. How could I get up here and not talk about Judge Trumper's order?
I'm sure she appreciates it.
And I think I complimented her this morning, Your Honor, or yesterday on her class certification order.
Yes, you did.
This order, of course, September 22, so it's a matter of 5 days after the emergency rule. And she issued a preliminary injunction, no denying that, in the North Mac school case. And Mr. DeVore likes to wave this around and say, 5 days after the emergency rule, injunction, exclusion case. Have to comply with Section 2, despite the emergency rules. Well, that's not exactly what happened. First, I think it's important to note that Judge Trumper, this is at page 5 of her order, Your Honor, but she makes it very clear that she was not given a statement from IDPH outlining the basis for the emergency. She says, I didn't receive a, quote, statement from IDPH outlining the basis of the emergency. Well, it wasn't her job to go find it, but the parties didn't give it to her. I would submit to the court that if she had had the statement of emergency, her decision could well have been different. What else? What else do we know from Judge Trumper's order? Page 12. She believed that, and this is something that you raised yesterday, Your Honor, she believed that the emergency rules and the executive order were inconsistent with the joint guidance. I mean, you even said it yesterday. Yeah, but the joint guidance says local health departments make the final call. Well, at one time it did. But the day before she issued this ruling, the joint guidance changed as part of the fluid mitigation efforts, and the joint guidance at the time of this order was completely consistent with the emergency rules. Judge Trumper didn't know that. It wasn't her job to go dig it up, but no one told her. And I again submit to the court that if she had known that, her decision could have been different. It's also clear from Judge Trumper's order that she understood the role of JCAR and emergency rules. She talks about it at some length, but the sum and substance is the second line in the second paragraph of page 5. Quote, once filed, JCAR reviews them and can either issue a recommendation, objection, or a suspension, period, close quote. Standing here in January, we know that JCAR never did that. They never issued objections or suspensions. And I would suggest to the court that in hindsight, particularly given Judge Trumper's detailed understanding of the legislative oversight, her decision may well have been different, because we know now that JCAR in its oversight obligation didn't object, didn't revise, didn't suspend. She also recognized, Judge Trumper did, discretion given to the agencies. Again, at page 5, she lays out the law. All of those things support the proposition that had she had a complete record, had she had good information, this order might have been different. But it really doesn't matter, because what's more important is what this order doesn't do. Remembering that this case is about two things in this precise issue on the emergency rules: masking and close contact exclusion. Mr. DeVore insists, and the plain theory of the plaintiff's case throughout their pleadings and for what we've heard literally for hours, is that you can't mask and you can't exclude for close contact unless you provide Section 2 procedures from the Public Health Act. I've already explained to you why that's not the case, because there's no Public Health Act order here, but we'll put that aside. Judge Trumper's injunction order doesn't say a word about masks. Not one word. It's not a mask order. So I don't know how it's authority for a mask order. But even more important, and Ms. Satterley raised this issue the other day, this preliminary injunction doesn't require that, it doesn't enjoin school districts from close contact exclusion unless Section 2 is complied with. It doesn't do that at all. What is the injunction? Paragraph B, page 17, quote, absent a finding by the local health department that this student and those in the potential class are deemed a close contact because of the public's health and welfare are significantly endangered, comma, the defendants are not allowed to exclude these students from in-person learning unless the student voluntarily consents to quarantine, a quarantine order is issued, the student consents to test to stay protocol, or the school has entered into an adaptive pause. So, what does it require? It requires school districts to work with the local health department And it requires the local health department to say, yeah, we've looked at your close contact information, and this child appears to be a close contact, so we're telling you, we're finding that there's a public health issue, period. And in that event, then nothing's enjoined. That is far afield from Section 2 and order. There's no order. 48 hours notice of a court hearing. There's no notice of a court hearing required. The right to counsel. The burden of proof denoted as clear and convincing. None of the procedural requirements of Section 2 of the Public Health Act are required by this order. Not one. So when Mr. DeVore says, do what Judge Trumper did, well, Judge Trumper didn't do what he's asking you to do. She didn't say, you can't exclude a close contact unless one of two things, consent or compliance with Section 2. She didn't say that at all. She said, talk to your local health department and to have them take a look at your close contact information. And do they find that this child is close contact? And if so, you're fine. Now, I don't think that fits into the law, because it doesn't solve the problem of Section 2 doesn't apply unless and until there's an order from the capital D department. But it's closer than what the plaintiffs are asking you to do, because there's nothing in here about Section 2. Not word one, and there is not a whisper about masks.
Let me ask you this, would you agree with me that the legislator did not authorize the Illinois Department of Public Health to delegate its duties and responsibilities to ISB or the school districts, but only to the local health departments?
I think that's a fair reading of the act. That I'm not sure about the only, but it certainly says you can delegate to the local health departments. And by my understanding of the practicalities, Your Honor, when the local health department is acting under Section 2, it is acting as the department. Just as if you were to delegate something to me as your agent, I'm acting for and as you. So when Section 2 requires action by the capital D department, if we're talking about something that was delegated, the local health department is, under Section 2 parlance, the capital D, thank you, department. For the record, the judge was cursively making the capital D.
I just saying, I'm following you.
I got it. So where does that leave us? Well, it leaves us as plaintiffs' claims cannot succeed unless there was no independent constitutional authority. There was. And there was no independent statutory authority under the Emergency Management Agency Act. There was. And the emergency rules are invalid. They were valid. They are valid. I've marched you through the procedures. And if all of those things are true, or not, more appropriately, not true, no constitutional authority, no statutory authority, and the emergency rules are out the window, then the plaintiffs can only succeed if, under the repealed rules, masking and exclusion for close contact, and for Allen's case, testing, is a quarantine or a modified quarantine. They're not. Why? Well, the global reason of why is that even under the repealed rules, quarantines under the Public Health Act and Section 2 procedures for quarantine require orders by the department. There are none here. Not one. Save for Mr. DeVore's time that he spent in a different courtroom in an action by the state's attorney on behalf of the Sangamon County Health Department. Not one, and paragraph 2M makes it very clear that the section 2 applies only to orders of the health department. And so does Foxfire. You're very familiar with Foxfire, Your Honor. I'm sure you remember this, but the appellate court in Foxfire, and it's a case there where the indoor dining prohibition is contested, and the theory of the case at the time was, no, That's a health department issue, and they didn't comply with the health, section 2 of the Illinois Department of Public Health Act. And Second District said, no, the appellate court in Foxfire said, no, these were issued under the Emergency Management Agency Act. This is not tantamount to a quarantine under the Public Health Act. Same thing here. They didn't spell it out. There's been no capital D order, but that's the ruling. And then it cites the Castle case. I remember Castle so well because it was the first published opinion we had on a challenge to the governor's executive orders in the late spring and early summer of 2020. It was a religious, brought by a religious organization, about I think it was 50 at the time, limiting the group of 50.
Yes, I think so.
And the theory of the case, one of the theories of the case presented to Judge Lee for a preliminary injunction was, no, they are limiting the grouping. That's the Illinois Public Health Department role. The governor's overreaching. And Judge Lee, in his opinion, cited by Foxfire, said, no, this is executive order action under the Emergency Management Agency Act. It didn't trigger the Public Health Act because there's been no action by the department. So that's the big reason why the plaintiff's claim fails even under the repeal rules. Why else? Well, because masking's not a quarantine. If masking were a quarantine, a public health department quarantine, or modified quarantine, under those old rules, requiring Section 2 procedures, then so is the Illinois Supreme Court's order. Because that order is the exact same. You have to wear a mask to get into a courthouse. Are we seriously going to consider a construction of the statute, and this is the argument, that if someone were to walk into the courthouse without a mask, and the sheriff's deputy refused to let him in, that then we would initiate a public health Section 2 proceeding? No. Why? Because when the Illinois Supreme Court issued an order statewide, you have to have a mask to come in the courthouse. It wasn't a public health department order. It was done under their independent authority over the court system, just as the governor's masking and close contact exclusions was done under his constitutional authority and the Emergency Management Agency Act. What else about masking? Even the modified quarantine definition says that it's for those, the first sentence, it's for situations where individuals are or may have been exposed. Masking isn't that. Masking is preventative. Masking is preventative. So the whole trigger for the modified quarantine definition never triggers. And we heard a new one the other day. Well, wait a minute, it's a treatment. Masking's a treatment. Here's the definition of treatment under the Illinois Administrative Code governing the Public Health Act. Treatment, quote, the provision of health care by one or more healthcare providers, period. Treatment includes any consultation, referral, or other exchanges of information to manage a patient's care, period, close quote. That's the end of the definition. It cannot be tortured so much to say when Section 2, I think it's E, talks about a treatment, that wearing a mask, compelling a mask, is treatment. There's no health care being involved. There's certainly no health care provider. It's not a treatment. And beyond that, we heard it this morning. This construction leads to absurd results. The modified quarantine definition, before it was repealed, read as follows. Modified quarantine. Quote, a selective partial limitation of freedom of movements or actions of a person or group of persons who are or may have been exposed to a contagious disease or possibly contagious disease, period. Modified quarantine is designed to meet particular situations and include, but is not limited to, exclusion of children from schools, the prohibition or restriction from engaging in particular occupation, or using public or mass transportation, or requirements for the use of devices or procedures intended to limit disease transmission, period, close quote. Then the definition continues. Now, Mr. DeVore's theory, the plaintiff's theory is, well, a mask is certainly used to, it's certainly a device intended to limit disease transmission. That's true. But if his reading is correct, then so is washing hands. Because it's undeniable that washing hands is a procedure. It's undeniable that washing hands is a procedure, I'm quoting, procedure intended to limit disease transmission, close quote. If using a mask triggers a modified quarantine, even though the public health department wasn't involved, and as a result of requiring a student to wear a mask, you have to go get an order from the public health department, then you have to go to court, then so do you every time students are required to wash their hands. And I think we all know over the last 22 months they've been required to do that a lot. And are we, that's the construction, because that fits perfectly. It fits perfectly. And I was struck by the presentation earlier, so does a Band-Aid. A Band-Aid is clearly a device intended to limit disease transmission. So, if this argument is correct, it leads to absurd results. And the cases are legion that statutes, rules, regulations aren't to be read to lead to absurd results. Same thing for exclusion, Your Honor. There's no capital D department order. And the Supreme Court order would equally be an exclusion because you're not letting people in the courthouse. Same thing. So even under the repealed rules, the plaintiff's claim fails. There's constitutional authority, there's statutory authority, the emergency rules are valid, even under the repealed rules. Masking, exclusion, testing does not trigger the Illinois Department of Public Health Act. There's no likelihood of prevailing. There's no protectable interest. For that reason, the motion needs to be denied. There's also no irreparable harm. That's required. Irreparable harm. Masking. The only possible harm we heard about that's in the record of this case is that maybe it's not healthy. Now, I'll talk a bit later about how that goes against all of the experts that are otherwise in the record. But the executive order has a specific medical exemption.
I was gonna ask that because I thought of this last night. So go ahead on that, because that was one of my questions.
So if a parent believes that it's their student has a medical issue and cannot medically tolerate a mask, the executive order has an exemption. They go to the school and they present whatever they have on the issue. They are not required to wear the mask if they're medically exempt. So either they're medically exempt and not required, or it's nothing but an inconvenience. Either way, there's no irreparable harm. Either you don't have to wear it because you are harmed, or you do wear it and it's inconvenient. Again, Your Honor, you don't have to look further than this room to find the authority on that. On this irreparable harm issue, you've issued two opinions on both sides. And I don't mean contradictory. I mean on plaintiffs' and defendants' side, because I presented a TRO to you. I was the movant in Hudsonville. And I said and argued to the court that if you did not issue a TRO compelling schools to mask, there would be irreparable harm. You agreed. You issued the TRO. You issued
you ruled the same on the other side, because I stood before you in the Murray case, and you ruled there's no irreparable harm for having to wear a mask, and then you denied that TRO. The same is here, and the cases are literally all over the country, Your Honor. It's footnote 17, we list them out for you in our opposition. Florida, Kentucky, Pennsylvania, Alabama, Connecticut, and obviously Illinois. Masking, there's no irreparable harm. There's not one allegation in this complaint, there's not 1 ounce of evidence in this record that even one of plaintiff's children have been excluded. None. How could it amount to irreparable harm? Beyond that, the executive order specifically provides that if there's a close contact exclusion, remote learning is required. Remote learning is authorized by statute in this state. How could an action, a short exclusion over a course of days that obtains remote learning that's authorized by statute be irreparable harm? Now, I can hear him already. No, it's not the masking, and it's not the exclusion that's irreparable harm. It's being denied procedures under the Health Act. That's the argument. Well, on the merits that fails, but it shows a misunderstanding of TRO proceedings. What's the harm? What's the harm if the TRO doesn't issue? The harm is I have to mask and I could be excluded for close contact. The violation, the alleged violation, is I get some procedures under Section 2. That's the merits. That's called merits. We'll get to that. In this case, will someday come to an end, and there will be a decision on that. But before we get to the merits, what's the harm of not having a TRO? Mask, and I may be excluded for close contact. TRO practice. I was thinking about this morning. What's an analogy here that will be easy to understand for all? I claim I own a historical building. Somebody else claims they own it, and they're going to knock it down. I file a TRO. What's my claim? My claim is I own the building, and you're violating my rights because I own the building. What's the harm? The harm if the TRO does not issue. The building gets knocked down. That's irreparable. That's irreparable. You may determine later, if this case were in front of you, you may determine 9 months from now, I don't own the building. But the TRO issued because the irreparable harm would have made my relief meaningless if it turned out that I did own the building, and that's this case. It's not the violation, the alleged violation. We'll get to the merits. It's the harm of not getting the TRO. And that harm is simply not irreparable because masking and exclusion, for the reasons that I've already stated, are not irreparable harm. Because of that, the TRO needs to be denied. I hate to even say this, Your Honor, but there's one more thing. Of course. And by the way, Judge.
I have that as 5. I thought you said there were 5 reasons.
Well,
maybe I misnumbered.
There's the protectable interest, likelihood of success.
Oh, right. Sorry.
We
yes.
marched through both of those.
Yes.
There's the irreparable harm, inadequate remedy. They're all often melded together.
Yep.
And then balancing.
Okay. Yep.
Now, I heard Mr. DeVore say, of course, when I had one more thing to talk about. As an aside,
that's
I
not
don't.
Just you. That's every lawyer.
Well,
just one more question.
I don't know this firsthand, Your Honor, but I've been told, because my colleagues have seen me, I've been told that there were bets in the office that it would be incapable of me for letting the districts go on for a day and a half and me not wanting to say things. I won the bet because I've waited my turn. I have waited my turn. So in due respect to Mr. DeVore, he's had plenty of time at this podium. I've waited my turn, and there is one more thing to talk about.
Okay.
And of course, it's balancing of hardships. And I use that phrase purposely, balancing of hardships. Because here's what the JL Properties Court said, 2021 Illinois Appellate 3rd, 200305 at paragraph 60. Quote, to obtain an injunction, the plaintiff must show the balance of hardships favors the injunction, period, close quote. Then the court continued. This was a case, if you remember, Your Honor, where Judge Anderson denied an emergency injunction regarding the eviction moratorium. And the appellate court held, quote, the circuit court correctly found that, one, both the state and the public had a strong interest in preserving public health, and two, these interests weighed substantially in favor of the governor and outweighed the harm caused the plaintiffs. Well, on the written record here, there's nothing that the plaintiffs have submitted to you. By my count, there were 6 submissions of the temporary restraining order motions and memos, because they were filed a couple of times. There were different orders, different case numbers. But through all the 6 filings, not one word. Not one word on hardship. What is the hardship? And what is the balancing that needs to be done? The balancing is the hardship to plaintiffs if the TRO does not issue, against the hardship to the public if the TRO does issue. That's the balance to be struck. And the hardship for the plaintiffs if the TRO doesn't issue is just like the irreparable harm issue. The hardship is you have to continue to mask while the case continues, and you may be possibly subject to close contact exclusion while the case continues. And again, Mr. DeVore will say, no, the balance is the violation of rights, but for the reasons I've already belabored, that's the merits. The balance of hardship is the masking and possibility of the possibility of an exclusion due to close contact. What does the record say in terms of the public? Because there's no record of harm and hardship for plaintiffs. Dr. Bleasdale, it's Exhibit 1 to our opposition, and I won't go through it at all, Your Honor, only to point out a couple of statistics. And again, Mr. Gerber will be interested because he made light of these statistics. At the time Dr. Bleasdale filed her declaration on December the 23rd, for those under 20, the case count had increased from September to 11 per 100,000 to 556 per 100,000. And after keeping track, when the Supreme Court issued their order, we were like at 250. When Mr. Gerber talked this morning, I think it was 96. And now in January, or in December, we're at 556. I looked the other day, I looked on the 15th, and this is the same IDPH website that the court takes judicial notice of. On the 15th of January, that number is now 1,936 per 100,000. Math's not my strong suit, but I calculated a percentage. I cheated. I went on Google and searched percentage calculator. 17,000% increase. 17,000% increase. And the most important thing to point out about that is that's with mitigations. That's with mitigations. Under 20. So by and large, children under 20. Since June, a 17,000% increase in cases. That's part of the record in this case from Dr. Bleasdale. She then explains in great detail that I know the court will read about the need for mitigations, what masking does, and what exclusion does, and why it's important in school. I leave that to the court, only to note that Dr. Bleasdale, whose CV is attached to her declaration that we filed the other day in response to Dr. Stocks, but it suffice it to say she's qualified. She concludes by saying the lack of these mitigation efforts will lead to sickness, public health issues, and possibly death. What else is there? If you look at the same IDPH website on hospitalizations, you will see that hospitalization data in this state is getting very dangerous. ICU beds, on December 2nd, ICU beds available. Oh, I'm sorry, patients in ICU beds with COVID, 534. As of January 13, 1,048. ICU bed capacity statewide is down to 8%. COVID patients make up over 30% of all hospital patients right now. And this last statistic, Your Honor, from the IDPH is the most striking as it relates to this case. Contact tracing data compiled by IDPH shows that 41% of people with confirmed or probable cases of COVID-19 report a school as a potential exposure location. Vastly higher percentage of any other location, vastly higher than offices, restaurants, grocery stores. In some regions of the state, Region 11, the Chicago suburbs, 50% of the cases report contact with school. And we're talking about issuing a TRO that's going to preclude, for practical purposes, going to preclude masking in schools. So those numbers are going to go only north. They will go up. I will leave it to Your Honor. You gave leave for the Illinois Federation of Teachers to file an amicus brief. It's, by our terms, Judge, pretty short. It's 11.
Yes.
It's 11 pages. And it's, I would say it's a good read, but in fact, it's a sad read. There is a paragraph I want to read. Quote, this is at page 2. The parent plaintiffs assert a right, in quote, to choose whether their child wears a mask on school premises and to decide for themselves what to do after their child has a close contact with an infected person. But these are not self-contained individual choices of the sort that implicate an absolute right to personal autonomy. Rather, they are choices that necessarily impact plaintiffs' fellow citizens. Whatever interests plaintiffs may assert, therefore, they cannot lay claim to an absolute and unconditional right to attend school free of COVID-related restrictions of the type they challenge here. In short, plaintiffs do not and cannot assert any interest sufficient to overcome the public interest in the health and welfare of school communities and of the larger communities. Amicus, you gave leave to file. And that leads me to Dr. Stock. The long and short of Dr. Stock's declaration, because in fairness, it's in the record. Paragraph 3, quote, based on my education, training, experience, and ongoing review of the academic literature in the context of COVID-19, it is my professional opinion that mask mandates in schools are highly detrimental to the health and well-being of children and unnecessarily restrict children's ability to learn, communicate, and receive communication, period, close quote. Then there's the additional opinion about masking leads to insufficient oxygen and too much carbon dioxide. So that's what he said. There's no denying he said it. But you can take judicial notice that that's already been debunked. The federal government's OSHA website, www.osha.gov/coronavirus.fax/worker.
the FAQ, quote, does wearing a medical/surgical mask or face covering cause unsafe oxygen levels or harmful carbon dioxide levels to the wearer? Question mark, close quote. Answer, quote, no. And then it goes on and on and on as to why. And then we, of course, also filed, Your Honor, on January the 12th, the declaration of Dr. Bleasdale in response to Dr. Stock's declaration, paragraph 13, quote, Dr. Stock's contention that mask mandates in schools are highly detrimental to the health and well-being of children and unnecessarily restrict children's ability to learn, communicate, and receive communication is erroneous and dangerous. And unlike Dr. Stock, in her declaration, Dr. Bleasdale gives you all the peer-reviewed studies that refute Dr. Stock's opinions. There's just not much there from Dr. Stock in terms of the balancing. And on balancing, Your Honor, I will leave you with words from you. Sorry, Doc.
Yes. Oh, thank you.
This is the ruling from the bench that we made in Murray. Specifically on balancing, page 90 of the transcript.
Page, sir?
90.
Thank you.
I'm beginning at line 13. Quote, so since the 4 elements necessary to obtain a temporary restraining order have not been shown, the court need not balance the hardships and consider the public interest involved, period. However, comma, if the court were to balance the equities of the parties, comma, the balance weighs in favor of preventing the spread of the virus through recommended masks. Because some people are asymptomatic, comma, this makes the wearing of masks essential. The court recognizes the discomfort of wearing masks, but the safety of our children is clear, comma, and enjoining the executive order at this stage would put the public at risk. That was in September. It's equally true, if not more so true now. Protectable interest, likelihood of success, they're not there. Irreparable harm, it's not there. Balancing of hardships is not close. So where are we? We are in a situation where the plaintiffs, undeniable, many of them, there's a lot of plaintiffs in this case. They disagree with Governor Pritzker's public health policy. They just do, and they have the right to do that. But that doesn't give them the right to a temporary restraining order. In reversing the grant of a temporary restraining order in Foxfire, the appellate court recognized this very point when it held, this is at paragraph 20 of the Foxfire opinion, Your Honor, quote, courts should refrain from considering the wisdom behind any adopted methods to combat the spread of disease, period, close quote. That's what plaintiffs are complaining about. They complain about the wisdom of the methods being utilized to mitigate COVID-19 in our schools. They have the right to complain. They have the right to vote for a new governor. They will exercise that right, I'm sure of it. But on the record here, and that's all we have, the record here, they don't have the right to a temporary restraining order. Thank you, Judge.
Need a break? Yes. I'm gonna cut you off at 2 o'clock.
Oh, I'll be quick, Judge, I promise you.
All right, Nancy needs a break though, so let's take a 5-minute
I do
break.
too, ma'am.
Okay.
Thank you.
How about you, Mr. DeVore?
Yes, ma'am.
Go ahead.
Judge, I must say, when I spent the last day and a half responding to my colleagues for the school district's arguments, it's like, okay, their argument's pretty straight, I get them, I can respond, the court sees it, answer that you decide is what you decide. I just listened to that for an hour and whatever, and to be honest with you, I kept looking in circles going, trying to write down notes, and I'm going, I don't know. Talking about OSHA, who lost a case. But the last comment, wrote it down again, Mr. Verticchio. When the Foxfire said about, they should not get into the adopted methods to combat the spread of disease. Okay with that? What are the adopted methods to combat the spread of a disease that we should be talking about? Governor Pritzker's orders that he's issued under some strained interpretations of law that I'll get to briefly, or under the clear and concise statutes and rules that deal with the combating of the spread of an infectious disease. Which one should we be looking at was not the question directly in front of Foxfire, but they say once the court determines what those rules are that it should be applying, it should apply those rules. I'm okay with that analysis. What I'm suggesting to you is the Department of Public Health Act and the Department of Public Health rules are the ones to look at, and not these strange interpretations of Emergency Management Agency Act. They talk about the Foxfire case. The Foxfire case said that not having indoor dining was not a quarantine. So the Department of Health Act didn't apply. Okay with that too. The court's going to say, you're going to decide, is a mask a type of quarantine? Is exclusion from school, which is what's written in there, Judge, is that a type of quarantine? If the court says they're not types of quarantine, okay. But if the court says, yes, I believe they are types of quarantine, then I say to the court, you should apply the laws that deal with quarantines, and that's consistent with Foxfire. Now, there was a lot to do about Judge Tromper's ruling that she issued on the 22nd. I want the court to read it in detail. Because what Judge Tromper did is she gave credence on that day to these emergency rules that said that school districts merely have to consult with the health department, because they changed the emergency rules to play the game, Judd. Talk about that briefly. And she applied that emergency rule as it was on its face, because, and guess what she also did on that same day, ma'am? She said that the state was a necessary party. Come forth in my courtroom and we'll talk about, because she, and you'll read it, critiques this emergency. It's been, again, 550 days of COVID. She never had a chance to ultimately vet what you're vetting. Okay? If you read her temporary restraining orders that were issued before the gamesmanship of the change rule, she clearly applies the Department of Public Health Act, because at that point in time, there had not been these changes to try to get around. She applied it. The independent authority under the Constitution, Judge, if you do anything, I hope we come out of this with an understanding that there is no constitutional power for a governor to control his people the way that we've been seeing. You should read Justice Gorsuch's opinion that he issued. This was the case that went up to them. It was a Supreme Court case, the Roman Catholic Church in Brooklyn, and Justice Gorsuch actually talks about Jacobson. And he points out, to the extent Jacobson had been used, according to him, to suggest that an executive can wield that kind of power was misplaced. And he says Jacobson did not go so far. They still want to rely upon him in your courtroom like a Supreme Court justice had, and said, well, wait a second. Jacobson didn't go as far as to say an executive can wield that kind of power. So independent constitutional authority to do these things, Judge, they've not given you any precedent that says, yes, a governor can wield constitutional power. The Butel case, I think, laid it out pretty well. His constitutional authority under executive orders, he can implicate his administrative agencies, people under his control. But to issue an order that hits a citizen of this state and says, you will do this because I'm telling you, doesn't go that far. Then we talked about the statutes, statutory authority, Emergency Management Agency Act, Department of Health. And they kept going back to, well, the Department of Health rules only deal with Department of Health orders. Judge, they're turning the conversation on you because we're here saying to you that the Department of Health has to be the one that does it. They can't say, well, it's not the Department of Health issuing it, as Mr. Berticchio did, but we only got one order in front of the court. We're here saying that this is the proper procedure. It's not that, well, of course the Department of Health orders and the laws only apply to the Department of Health. The question for you is the Department of Health the one to be doing these things? And if you say yes, of course those laws apply. They're trying to argue to you that the Department of Health this is not their purview. That's what they want you to find. School districts want to say it's theirs. Governor wants to say, I guess it's his until he sees fit. So again, Judge, that's a mischaracterization. Does the Department of Health Act apply? Yes or no? We're asking you to say that it does. And again, they talked about some of your prior rulings, trying to use them against you. I thought was inappropriate, but so be it. Judge, those rulings aren't inconsistent. Because as you have been made clear, we're not here asking you to say masks should never be worn. We're not here asking you to say children should never be excluded. We're here asking you to say if those are going to happen, that meaningful rights under the law be provided to these citizens. That's what we're asking you. That's what we asked everyone else. There is a fundamental right of if we do not have a fundamental right of people to say we have laws in place and they protect us, please, court, make these laws protect us. If that's not a right, I don't know what is. I don't. And to say that it's not irreparable, again, we've given you the law, but again, let's just have common sense as jurists. If we can say the laws that protect our people can just be cast aside and that's not irreparable, then what is? I don't know. I don't know, man. This whole issue, and again, Mr. Berticchio, as clever as he is, never really touches it. This emergency rule change. Judge, they had all of their mechanisms in place, and he tries to talk about, well, I wrote it down that COVID was what was the language that he used? Moving target. It's being as modest as I can be. It wasn't COVID that was the moving target that their emergency rules making. It was the rulings from the courts that I was involved in. August 30th, September 1st, September 3rd, September 10th, September 17th. Court after court after court did the same analysis that we're asking you to do today. And they said these children have rights to be protected. They said it's irreparable if we don't protect them. They balanced the hardships where I'm going to leave you with here. And they said, based upon that, equity demanded that an injunction enter. I'm going to leave you with this, Judge, because I know it's 2 o'clock. I've got 2 provisions that I want to be able to just give you briefly. And it was dealing with the balance of the hardships. It lays it out much better than I could possibly do it justice. Page 17 out of 20, Judge Tromper, September 10th. This is a restraining order where she, in fact, said the health rules apply. And she said the defendants argued that the school and the local health departments, if they have to comply with the law, would result in hardship to healthy students who are not deemed a close contact and not subject to quarantine. In other words, the districts argue that even though students have not been deemed a danger or substantial risk of spreading an infectious disease subject to quarantine, that their return to school would cause great harm to children who are masked and socially distanced. This was the argument. And the court agreed. Again, I think she did an excellent job. She didn't always agree with me. Has to be consideration to this potential harm that might result to those healthy students and staff. who have not yet been considered a close contact, and who are also entitled to in-person learning to benefit that they may be receiving. She says, but the health experts are the ones who decide whether a close contact is considered a danger and a substantial risk to the public safety and should be quarantined or excluded. If these other, here it is, Judge, if these other government bodies will comply with the law as written and close contacts are properly quarantined, then there will be no risk to the healthy students who are still receiving in-person education. That's where she balanced the harms. And all of her arguments, that's where every other judge balanced the harms. I want to read it again. If these government bodies comply with the law as written, and those close contacts are properly quarantined, then there will be no risk to the healthy students. Then she goes on to say, the pleas from the medical community are not an illusion, they're real. The number of people being diagnosed with COVID and its variants is real. The number of breakthrough cases for vaccinated people is real. She says the number of hospitalizations are real. She talks about the health department and our medical providers. She says they're trying to save people's lives, loved ones, friends, neighbors, etc. She says the law, which the court did not write, has imposed a burden on these healthcare workers, namely the local health departments. They are selflessly trying to do their job. This is where it gets good, Judge. Yet society in this current pushback, because people experience restrictions like they've never seen before. They've watched and observed as other neighboring states eased their restrictions while their freedoms were still being suppressed. While they were threatened of being arrested and charged criminally, while other convicted criminals were being released from the streets. This mixed information and lack of consistency, the ever-changing goalposts, people have had enough. They finally understand what the law says and does not say, and they feel that they have a right to protect their freedoms. When the legislature created the laws, they did so knowing that people have a fundamental right to due process. That quarantining someone is the essence of taking one's liberty and freedom by placing them in a form of house arrest. The representatives in their infinite wisdom understood that governments just cannot order people to do certain things, hence the reason we're here today. Lastly, she said, the law works both ways. The government and its local units of government cannot expect and demand its citizens to follow laws imposed against them when those same public entities are not willing to comply with similar laws that they are mandated to implement and follow. And then she went on and said, absent a finding by the health department that this student is deemed a close contact and subject to mandatory quarantine because the public's health and welfare are significantly endangered, the defendants are not allowed to exclude this student from in-person. Judge, I couldn't say that any better. That's why I wanted to read it to you. In her other opinion, she talks about the same thing, and she lays out how it's the legislature who balances the interests, our public interests, and our rights as individuals. And I submit to you that the legislature has balanced those interests when they created these laws. So granting my clients relief does not throw masking out the window. It does not throw exclusion from school out the window. What it says is that if you, as the school districts, as the health departments, if you want these things to happen, you need to follow the law. The law that it says in Section 2, when you're dealing with quarantine, the health department is the supreme authority. The supreme authority. I listened, and I listened closely, and we all know statutory construction deals with the specific over the general. I heard Mr. Verticchio go on and give some most strained interpretations of provisions of occupancy and other of the Emergency Management Agency Act, saying that gives Governor Pritzker the authority to do these things. Judge, if that was the most general that's a more general interpretation than the school districts were trying to do. We've given you the specific provisions. Judge Schieffer, Chief Judge Jarman, Judge Grunke, Judge Tromper, Judge from Adams County, they all said these children have rights when it comes to these masks, which are a device intended to limit the spread. When it comes to exclusion from school, they all have rights, and their rights needed to be protected, and we're asking you to protect their rights. Thank you.
All right. Thank you, everyone. Thank you for working through lunch. I am going to take this under advisement. I am not prepared to issue a ruling at this time. There is a lot of information. I'm not mandating, but I am telling you, if anyone wants to submit a proposed order, you can do so. And you can submit it to me in Word format, email it to me. Do not file it with the clerk's office. Make sure everyone's on it. You can just use one of the emails that we have been circulating amongst us. Just looking at my calendar here. I know it's not long, but I would ask that you have those to me by the 27th of January. And if you don't submit one, that's fine. I'm just throwing that out there to anyone. And on another administrative matter, do we want transcripts?
I've got it.
You did it yesterday, Mr. Verticchio, but you're okay with that?
I'm fine, Your Honor.
Okay.